here at the School of Law. I'm so excited to welcome those of you in person and the many of you tuning in virtually to BU School of Law and to this conference after Roe and Dobbs seeking reproductive justice in the next 50 years. One of my colleagues, Aziza Ahmed and Nicole Huberfeld, and I began planning this conference a year ago, in a week or so. Our working title was Looking Beyond Roe versus Wade as it turned 50, but with the leaked Dobbs opinion back in early May, that shifted to after Roe and Dobbs. We have a very full day with 5 panels filled with an amazing group of speakers doing significant work on all aspects of reproductive justice. And I just want to give a big shout out to Elizabeth Clancy for her invaluable help with organizing this day and the entire team in the communications and events office. So thank you, Elizabeth. To welcome you officially, I am delighted to introduce our dynamic dean, Angela Nwaki-Willig, who is also the inaugural Ryan Roth Gallo and Ernst J. Gallo Professor of Law, the nation's first endowed professorship in critical race theory. To recite all her accomplishments would take longer than our opening panel. And in any case, the dean probably needs no introduction to many of you, as you are aware of her far-reaching scholarly work and her national leadership on issues of racial justice and law and matters of legal education. Prior to joining BU Law in 2018 as our dean, she served as Chancellor's Professor of Law at the University of California, Berkeley. In 2021, the dean was elected to the American Academy of Arts and Sciences. She's a renowned legal scholar and expert in racial and gender equality, as well as anti-discrimination law, and writes in numerous areas, including employment discrimination, family law, and critical race theory. Most recently was a co-editor on an exciting new volume, which I've already incorporated in my teaching, Critical Race Judgments. I know that reproductive justice is an issue of extreme importance to the dean. Aziza, Nicole, and I are very grateful for her support of this conference. We also praise her vision in supporting our efforts to start a new program here at BU, about which she'll tell you more. And we also thank her for allowing this conference to be the beginning of this program, as well as a part of the celebration of BU Law's 150th anniversary. And it's now my honor to introduce to you our dean, Angela Nwaki-Willig. Thank you.
Good morning. I'm Angela Nwaki-Willig. I'm the dean, and I'm delighted to welcome you to this wonderful event about a symposium about reproductive justice. I have a few reminders before we get started today. The first is that we want to ask everyone to please take a moment and mute all of your electronic devices. Make sure that you've muted them. And second, please note that this program will be conducted in accordance with the principles of the university statement on free speech and expression, which emphasizes the importance of respectful discourse during which ideas can be freely expressed and challenged. Interruptions that limit the ability of any of today's presenters to be seen and heard will be regarded as a violation of the rights and responsibilities upon which this community is based. University officials will ask anyone who disrupts the event to refrain from further disruptions, and anyone who does not comply will be asked to leave. So thank you in advance for your cooperation on these points. Third and finally, I want to note that it's wonderful to have so many esteemed colleagues from across the country here with us in person today and participating virtually. We have 450 registrants, so it's a full room, but we also have lots of people who are logged in and watching from afar. And so everyone's presence at this conference demonstrates how critical this conversation and the symposium is. So as we mark what would have been the 50th anniversary of Roe versus Wade, we must acknowledge the legacy of the landmark decision, a legacy that is impossible to overstate. Since June 2022, when the Supreme Court decided to overturn 50 years of precedent from Roe and Dobbs versus Jackson Women's Health Organization, generations of people who grew up with a stronger sense of control over their own bodies have had to come to terms with some loss of that agency. Within 100 days of Dobbs, dozens of clinics and states that had passed abortion trigger laws closed, leaving women and others with reproductive capacities who live in those states without easily available access to health care, that would allow them to control their reproductive choices. Those constraints have had immediate implications for healthcare and budgets in other states, like our own, because people are crossing state lines to access the healthcare they desire and need. Many providers in states with new abortion restrictions have no idea how these new laws will be enforced, so they're changing practices that were once routine to avoid the threat of legal charges. I've read story after story about patients experiencing ectopic pregnancies, incomplete miscarriages, and other obstetrical conditions, only to be turned away by doctors who fear being charged with facilitating an abortion. These patients face prolonged pain and suffering, and in the worst cases, patients who are miscarrying are dying from an infection or hemorrhaging. All of these impacts are worse for immigrants and people of color, who are significantly more likely to die during childbirth, regardless of education or income. Black women, for example, are 5 times more likely to die from pregnancy-related heart failure and blood pressure disorders than white women, and acute or chronic health conditions that can result in complications with pregnancy are among the top factors that lead people to seek abortion care. So less access to reproductive health care will undoubtedly result in more deaths of Black women, of immigrant women, of women who are incredibly vulnerable in our society. So this is why today's symposium is so important. It's an opportunity to gather as a community, to spark conversations and envision new solutions. It's a chance to re-energize one another and recommit to the cause. It's a time to re-envision what a post-Roe, post-Dobbs world could ideally look like. As Dean Kimberly Mutcherson of Rutgers Law School has explained, for many advocates of choice, Roe itself was not perfect. For those of us who are seeking to bring and build back reproductive rights, we have to think carefully about what we are seeking to build. As Dean Mutcherson has highlighted, Roe had its own problems. It focused too much on doctors and not enough on women and those with reproductive capacities. Others have critiqued Roe's grounding in privacy rather than sex equality, while others have lamented Roe's failure to promise and ensure equal access to abortion care. After all, Roe did not determine that states had an obligation to provide access to abortions, particularly for low-income women, which enabled the Hyde Amendment to prevent the use of Medicaid to pay for abortions, which in turn meant that the most economically vulnerable women had unequal access to such care. At Boston University School of Law, we are more committed than ever to forging and facilitating these critical conversations. And I'm excited to share that we are launching a new program on reproductive justice, led by these 3 professors, Professor Linda McLean, Professor Aziza Ahmed, Professor Nicole Huberfeld, and that will create a home for sustained multidisciplinary focus on reproductive justice at Boston University. Beginning in the fall of 2023, students will be able to take advantage of deep faculty expertise here at the School of Law and at the Schools of Public Health and Medicine, the Department of Women, Gender, and Sexuality Studies, the College of Arts and Sciences, and the Center for Anti-Racist Research. The program on reproductive justice will foster student interests and career opportunities through a broad-based interdisciplinary approach that includes not just protections for constitutional rights, but also medicine, public health, ethics, social movements, and more. In addition to Boston University, the city of Boston is a perfect site for these explorations and discussions. Boston has a long history of women's health organizing, including the Boston Women's Health Collective, which wrote Our Bodies, Ourselves, and revolutionized reproductive health care. And Boston University was the site of a watershed event in the struggle for reproductive rights, when during a 1967 lecture in front of 2,000 BU students, pro-choice activist Bill Baird gave an unwed student a contraceptive and was immediately arrested for violating Massachusetts crimes against chastity, morality, decency, and good order laws. Baird took his case to the Supreme Court in 1972's Einstein versus Baird, won the right for unmarried couples to use birth control. This symposium and the new BU program on reproductive justice continue this tradition of national leadership on these issues. On behalf of everyone at Boston University School of Law, I want to express my sincere gratitude to all of today's speakers and all of our participants. Thank you for taking time to join us in these important conversations. And I want to thank the BU School of Public Health who co-sponsored this event. I'd also like to thank my colleagues, Professor Aziza Ahmed, Nicole Huberfeld, and Linda McLean, and Elizabeth Clancy, I think who's now back in the back now, our events and conferences manager, for organizing today's symposium. Finally, I'd like to take this opportunity to recognize two BU Law alumni, Margaret Daly, Vice President at Charles River Associates, and Deborah Barnard, Professional Growth and Development Partner at Holland and Knight, who have made the first ever gift to support the program on reproductive justice. Our graduates have made lasting impacts on society, and gifts like this one are critical to helping us provide our students the foundation from which they can continue this important work. We encourage, and I would be remiss if I did not say this, we encourage others to support this critical work at Boston University, to support the program for reproductive justice with their time, their treasures, and their talent. And we thank you for joining us today.
Thank you, Dean. It's so exciting. I now like to introduce my colleague, Nicole Huberfeld, to welcome people on behalf of the School of Public Health.
Hi, good morning. Welcome. Aren't you glad this rain isn't snow so that we could be here together today? I'm Nicole Huberfeld, the Edward Audley Professor of Health Law at BU School of Public Health and a Professor of Law at the School of Law. And it is my privilege to not just welcome you, but thank you. Thank you to those of you who have come from far away to be here today. Thank you for our speakers' attendance, but also those of you who are simply interested and want to be part of the conversation. Thank you to the people who are participating virtually. As you heard before, we have hundreds of people participating online as well. And so I have a couple of logistics, but also just a few quick remarks. I also want to thank George Annis, our Warren Professor and the Director of the Center for Health Law, Ethics, and Human Rights at BUSPH for supporting this program all the way through. And of course, the Chair of the Department of Health Law Policy and Management, Michael Stein, and the Dean of SPH, Sandro Galea, for their support in this, in addition to, of course, our own Dean Onwuachi-Willig and my colleagues, Linda and Aziza. This has been an incredible year-long journey. I also want to thank our student chapter of If, When, How, who are helping to be ambassadors today. So if you have questions and you see an If, When, How student, they will help you. And also the president of If, When, How, Shannon Gonick, will be moderating our fourth panel today. Part of the SPH mission is to improve the health and well-being of populations worldwide, particularly the underserved. And this is informed by a core value to promote justice, human rights, and equity within and across our local and global communities. This is consistent with public health as a field which is dedicated to reducing risk and harm for illness and injury. I think it's fair to say that Dobbs has created strong headwinds for these projects. It's not just that Dobbs created a sea change in the law, but also that it sowed chaos and confusion and conflict between the federal government and states, between states and other states, between healthcare providers and states, and confusion especially for patients and healthcare providers. This increases risk for people of reproductive age and who are capable of pregnancy. It increases moral distress for clinicians and healthcare professionals writ large, and it makes it so that health inequities will be deepened in our nation. I can't help but recall the famous words of Dr. Martin Luther King 57 years ago when he spoke to the Medical Committee for Human Rights. Of all the forms of inequality, injustice in health is the most shocking and the most inhuman because it often results in physical death. Now more than ever, our multidisciplinary conversation is critical, and today we demonstrate our commitment to that in Boston, in the region, in the country, and around the world. Thank you for demonstrating your commitment by being here today. I have a couple of logistics. First of all, most of the programming occurs in this room. However, the 12:45 panel is in room 102. So that will be after lunch. You'll head to room 102, and then we'll come back to this room after that. Lunch will be set up outside this room. We also have an overflow set up so that if you leave, maybe you need to do something else during the course of the day, you can go to the 5th floor. Rooms 526 and 528 are available for overflow and watching virtually, but still with other people. restrooms are right outside this door, but also if you go down the hall past the lockers, there are additional restrooms and you can refill your water bottles there as well. Just a reminder to our virtual audience that we need you to use the Q&A function to supply questions for our panelists, and the moderator for the panel will pick up on your questions and share them with the group. And for the people in the audience, if you wouldn't mind to use the microphones that we have available, that will help people to hear your questions, which is just as important as everything we're doing today. Finally, our intent is to use inclusive language, but as you're aware, this is a slow change in that the law and other official documents still use the gender binary. A lot of the data still uses the gender binary. And so while we do want to be inclusive and to grow that aspect of the reproductive justice movement, sometimes we do still need to use the language that is rooted in the gender binary. Thank you so much. We're so excited to have you. Have a wonderful day.
Okay. I'm moderating our first panel, which appropriately enough is called Beginnings. Conferences always start with history of various forms of it. So I just wanted to say that this is my only thing I'll say other than introducing the panel. My very first academic conference was called Reproductive Issues in a Post-Roe World, hosted by Martha Feynman's Feminism and Legal Theory Project 30 years ago or more. And held when it seemed the court might overrule Roe and Planned Parenthood versus Casey. And here we are basically 30 some years later. So I'm very excited to moderate this opening panel focused on various types of history and the use and misuse of history concerning reproductive rights and justice. As will all our moderators, I'm giving very brief introductions of the speakers. Their full bios are on the website to provide more time for their remarks and for your comments and questions. The missing chair, my colleague George Annis, want to come up to the, okay, you're going to come up, okay. You've already heard about his role at the School of Public Health. I would just say that along with being the William Fairfield Warren Distinguished Professor, he's also, among many other things, director of the Center for Health Law, Ethics, and Human Rights at BU School of Public Health, a member of the Department of Health Law, Policy, and Management at the School of Public Health, and a professor here at the law school, and also at the School of Medicine. He's the author or editor of 20 books on health law and bioethics and numerous other publications. Our second speaker, Professor Radhika Rao, a professor of law at University of California, Hastings College of Law, was a clerk for Justice Blackmun, author of Roe versus Wade, as well as Justice Marshall. Her many writings in constitutional law and in the law of the human body include such topics as abortion, assisted reproduction, cloning, stem cell research, genetic privacy, gene patenting, and property rights in the human body. We're very grateful she came all this way to be with us in person. Third, joining us on Zoom is Reva Siegel. Professor Siegel is a Nicholas D.B. Katzenbach Professor of Law, Yale Law School. She writes on law and inequality and how courts interact with representative government and popular movements in interpreting the Constitution. She was a co-author of the Equal Protection Amicus Brief written with Serena Mayeri and Melissa Murray in the Dobbs case, and has written several articles about the case on which she'll be drawing in her remarks today. Most significantly, Memory Games, Dobbs's originalism as anti-democratic living constitutionalism and some pathways for resistance, and Equality Emerges as a Ground of Abortion Rights in and After Dobbs with Professor Carrie Franklin. And finally, Paul A. Lombardo, the Regents Professor and Bobby Lee Cook Professor of Law at Georgia State University. He's a lawyer historian who served from 2011 to 2016 as a senior advisor to the Presidential Commission for the Study of Bioethical Issues. Relevant to his presentation this morning, he's written extensively on the legal history of the American eugenics movement. We're now going to start with Professor Annis. Each speaker will take 10 to 12 minutes, and then we'll have hopefully ample time for comments and questions. Thank you. And I'll be keeping time.
This is the beginning, the end. It's neither one, right? We're in this debate forever, and it will never change, I don't think. I'm going to make an argument, a historical argument, that there are many opportunities to do better or worse than the abortion debate, and we should make sure, I'm sorry, I don't want to include everybody, that we pick the right ones and that we don't ignore them. I have always thought, and this is a case that came down, unlike most of you, after I graduated from law school, so I never got the learning of my professors as how they would look at Roe. But that was a long time ago. Obviously, we know it's 50 years. Of course, it's a long time ago. But I do feel in a time warp. We've heard about Harry Blackman. Harry gets a lot, he's from my home state of Minnesota. I always liked Harry a lot. Yes, he did write his opinion about doctors. That's true. I mean, that's just true. And was he too heavy on doctors and too light on women? Yeah, of course. It was the times. It was 50 years ago. There were no women on the Supreme Court. I mean, that's, you weren't going to get an equality opinion. So I've always thought, of course, I'm in law and medicine, so this has always been the most important opinion in my career, that Harry did us a favor in many ways. It was an uncontroversial opinion. You have to remember, you all know it was 7-2, but it was not talked about in the press very much. Even the day that it ruled that Roe came out, you can see the headline was that Lyndon Johnson had died. It wasn't that Roe had been decided. Harry has a time at Boston University. I think we want to acknowledge he was here. We honored him. He not only helped keynote a conference, he helped put together this issue about him, about Harry Blackman, and the Supreme Court. The subtitle is what I want to point you to, and the limits of medical privacy. Limits of medical privacy. No, I mean, right now we're trying to think about, do we want to stick with that privacy, or is privacy done? Should we just get off privacy and move on? I would highly recommend that we not get off privacy, that's still extraordinarily valuable outside of the realm of whatever you think of it in terms of abortion. Justice Blackmun at this conference at BU in 1987 gave a whole list of things that he thought the court might get involved with. He said he wasn't that excited about the court getting involved with them. He hoped that doctors and lawyers working together could resolve some of these problems for the society without going into court. And I just want to acknowledge my friend and colleague who I worked with for more than 30 years. He unfortunately died 8 years ago, Sherman Elias, who's a leading obstetrician geneticist, chair of the department at Northwestern, taught me everything I know about obstetrics, but couldn't have done any of the work that in the last 50 years that we did together without Dr. Elias. I just want to know. And one of the things we did, and again, it was because of him, is wrote the chapter on law and ethics in the standard obstetrics textbook. And I think that's one way we've had some influence on physicians. And one way physicians have, I think, no matter what they tell you in person, have always relied on privacy, the privacy of the doctor-patient relationship, and Roe v. Wade in their practice of medicine. And they're afraid now. And in some ways, I don't blame them, right? I've always argued doctors should have more moral courage, but why should they? I mean, why should they take the risk going to jail for their patients? Again, I think they should, but who am I to say? They're the ones that are doing it, and we should have a world where they don't have to risk going to jail to take good care of their patients. So, since Roe, the opposition, or people who thought Roe was wrong, have made, I think, 4 basic arguments. We can talk about this today. That people who do abortions aren't real physicians. Abortion is not a real medical procedure. It's a fringy thing. It takes the right to life from babies, and it harms the not-to-be mothers. Those arguments have to be met, I think. I mean, I think it's just wrong. The first 2 are just wrong. The last 2 are very difficult. So we get lots of images, lots of pictures, and the question is, should we go back to them? This is my favorite picture in the whole abortion debate. Many of you recognize this. This is George Bush signing the so-called partial birth abortion law, surrounded by, I mean, really, this is the idea. You couldn't find one woman in Washington, D.C.? That's just, that told them nothing, I don't think. Justice Kennedy, my favorite line from Justice Kennedy's opinion in the partial birth abortion case was that, oh, it doesn't matter if we take away this particular procedure, doctors can always give the fetus a lethal injection and kill it. Thank you, Dr. Kennedy. I mean, really? And then, of course, this doesn't even need a comment. Just get 3 new people and you change the law, and end the story, right? So I'm going to talk very briefly about 3 stories. As I'm going to make my basic argument is that we need to tell our stories better. Now, I'm not the first person to say that, but it's important to be said again. Stories matter. We've seen that more and more in politics. It's been unfortunate in some senses, fortunate in others. But Annie Ernaux, I'm sure you all know, won the Nobel Prize this year in literature. And it's been speculated, although the Nobel Prize Committee is not talking, that one of the reasons she won, at least, was for her magnificent and horrific book, Happening, which is about her back alley abortion when she was a young woman in Paris. And if you haven't read it, you have to read it, even though you won't want to read it. It's just because it's so horrific, but it's real. And it's the way many women got abortions before Roe. The next story is a story from Boston, the story of Ken Edelin, who was a young Black physician at Boston Medical Center and did an abortion. Well, did more than one, but did this particular abortion he did in the year of Roe. It was after Roe had been decided. The law was very confused. But the district attorney, Newman Flanagan, thought that he should be prosecuted. And there was no law against abortion in Massachusetts. Even if there was, it would have been stricken down. But that didn't stop him. Then that doesn't, that case was brought as a manslaughter case against Dr. Edelin. It's his lawyer who always gets in the center of the picture, of course. Since we're in a law school, I guess that's okay. Outside of Superior Court, that's Bill Holman's terrific lawyer. It's an amazing case. I actually sat in on a few days of it because I graduated from law school a few years before this case. And I knew Ken as a colleague. I didn't know him personally, but he was a wonderful human being. There's no question about that. But the point of this case and what made it so interesting is the way all the judges, and this was the appeals court, he was convicted. The jury had no trouble convicting him at all, essentially an all-white male jury, basically. And we have to say they're all Catholics as well. I guess we do. We don't have to say that. I always get in trouble. I'm an old Catholic. I say all kinds of things about Catholics, but that's not a reason to convict someone of manslaughter. Anyway, he was convicted, and the court overturned the conviction easily, but struggled. Many of the justices struggled. How should the law regulate medical procedures? How should the law regulate doctors? And we're talking about that again today. It's still a valid and a good question, but they shouldn't send them to jail for doing routine medical procedures with the patient's consent. Finally, the third is a novel. I'll just commend it to you if you don't remember it. It's about 20 years old now, but it's terrific. And it makes you think about rules, who sets the rules, what they know about what they're doing, and what rules actually matter to human beings. 3 other stories just to show you that actually stories of one person changes the law. This, of course, is the change of the law in Ireland, the death of this young woman because the doctor was afraid to help her. The Quinlan case and the case of the Cruzan case. Those cases, I mean, virtually everybody that I knew in the 1976 that the Quinlan case said, I don't want to be like Karen Ann Quinlan. The public was just absolutely set on that. And of course, Brittany Maynard for physician-assisted suicide, just basically by herself, by her death, changed the California law. And they matter, And I leave it to you. Thank you for giving me the opportunity to open this extremely important dialogue, it seems to me, from wonderful people. And I want to thank especially Nicole Huberfeld in the Center for Health Law, Ethics, and Human Rights for all her work on this.
Yeah.
Thank you.
Thank you. An exemplary example of staying within time limits. Thank you. Example, okay. And now Professor Rao, speaking of Justice Blackmun. Okay.
Oh, thank you so much for having me here. It is such an honor and a privilege to be here with all of you. And George said we should tell our stories. So I had the privilege of clerking for Justice Harry Blackmun, and I also happened to be clerking at the court the year that Planned Parenthood against Casey was just decided. So I'm going to tell some of my stories here. Justice Blackmun, author of Roe, he used to say, I'll carry that label with me to the grave. He did, in fact, of course, carry that label with him to the grave. And thankfully, he's not here to witness what would have been the 50th anniversary of Roe versus Wade and its replacement with the, I think we can say, infamous opinion in Dobbs. But I wonder what would have been his reaction to the Dobbs opinions. And I think that he would have been appalled, but not shocked by the opinions in Dobbs, because he really understood the precariousness of the right to an abortion, the right that he fought for, his 24 years on the Supreme Court so staunchly to defend. And Linda was talking about 30 years ago, a conference to just post Casey. In Planned Parenthood against Casey, 30 years ago, the Supreme Court actually was on the verge of overturning Roe. But one justice, Justice Anthony Kennedy, Dr. Kennedy, I guess, as Professor Annis referred to him, stepped back from the brink, and he switched his vote at the last minute, and he decided to join 2 other justices, O'Connor and Souter, who had both been appointed by Republican presidents as well, all 3 of them, to retain and reaffirm what they called the essential holding of Roe. And Casey, I think, as precedent, is really instructive to us today, because today a narrow majority of the court declined to kind of step back from the brink. Chief Justice John Roberts really looked like was lobbying and trying very hard to attract a vote to his concurring opinion, which would have been a more measured, I think he was suggesting, response to not go all the way and overturn Roe. But he was unable to do so. And 8 months after the Dobbs draft opinion was leaked, the Supreme Court just last week issued a report, which was inconclusive. They were not able to figure out, surprise, surprise, who was the leaker by a preponderance of the evidence. Even after interviewing, I think, over 80 law clerks and court employees, they said, and but not the justices under oath. They did finally, I think, speak with the justices. Anyway, Casey itself provides perhaps a plausible motive. one potential motive for what could have been a reason to leak the draft opinion, and that was to prevent that kind of defection that occurred at the time of Planned Parenthood against Casey. But of course, it wasn't successful. So what would Justice Blackmun say to Alito's opinion? In Dobbs, Alito, of course, is incredibly disrespectful of Roe in his opinion. He mocks Roe's language and ridicules its reasoning, saying that it's egregiously wrong and exceptionally weak. I think Justice Alito's incredibly intemperate remarks about Roe look even more so if you know something about the secret backstory of Roe, which is that Roe, although many people attributed it and criticized and castigated its medical framing, as George Annis was talking about, and its failure to ground the right in equality, many attributed that to Justice Blackmun. The medical framing of Roe, although Justice Blackmun was the chief legal counsel at Mayo Clinic, and he spent the summer researching, the summer after Roe was first argued, researching at the Mayo Clinic Library. His original opinion, if you actually examine it, was a much narrower opinion. He would have found the law, the Texas law, to be unconstitutional on vagueness grounds. But he was, in fact, there were many suggestions and editorial provisions from other justices. So that original Roe opinion was much more the product of a collaborative effort among the different justices and not solely attributable to Roe. And I think in that sense, Alito's remarks seem even more intemperate, and his criticism of Roe looks even less legitimate. So it was actually Justice Lewis Powell who suggested the viability line to Justice Blackmun. And Justice Brennan and Thurgood Marshall agreed with the viability line. Justice Blackmun was so diligently trying to assemble a majority for Roe that he really bent over backwards to accept the comments and suggestions of many others. And his draft opinion really reflected this kind of collaborative give and take of an opinion, which was remarkably collegial for the time as well. So that's part of, I think, the underpinnings of Roe, which is little known. And George Annis has also said that Roe wasn't really considered to be controversial at the time. One of the less well-known stories of Roe is that when it came before the court was short of two justices. Justices Harlan and Black had recently retired due to illness. And so the Chief Justice at the time, Warren Burger, established a screening committee of 3 justices, which included Potter Stewart as its chief and Blackmun, as well as Byron White. And the screening committee was supposed to select only non-controversial cases for oral argument that year. And one of the non-controversial cases that they picked was Roe.
Wow.
So Roe, they just didn't understand how controversial it would be at the time. The newspaper headlines that you saw, so it really was not considered to be the kind of a case. But when they heard oral argument in Roe, Justice Blackmun kind of realized the controversial nature of the opinion. And so he suggested, when he was given the task of writing a memo in the case, that the court should hold the case over for re-argument the following year. And it was because of that time period, he said, sounder minds prevailed, and they decided to hold the case over for re-argument. So it could be argued before a full court, and you could get a panel of 9 justices rather than 7 to issue an opinion in the case. Because Justice Blackmun thought that a case that was so important and so controversial, even though he hadn't originally realized it, needed to be decided by a full court. And that was when he retreated in the summer before the case was held over for re-argument to the Mayo Clinic, where he did all of that extensive research, the research that is really ridiculed by Justice Alito in his opinion. So that's part of the backstory of Roe. The other part of the backstory is, why didn't the court rely upon equality? And Roe has been criticized on so many sides, assailed by friend as well as foe, for its reliance upon this medically approved autonomy idea. RBG used to criticize Roe on that count, and its failure to ground the right in sex equality. Justice Blackmun was really sensitive on this score, but he always pointed out that all of the briefs and arguments only relied upon privacy and due process. There wasn't really an equality argument to be made, because the court didn't even view pregnancy discrimination as a form of sex discrimination at the time that Roe was decided. Many of you may recall that a year after Roe was decided, in a case called Geduldig against Aiello, the court ruled that pregnancy discrimination didn't even constitute sex discrimination, nor was sex discrimination a suspect or quasi-suspect class entitled to heightened scrutiny. So that argument really would not have held water at the time. Both on equality and on medical autonomy, thank you, Roe was criticized, but I think it was very much a product of its time, and poor Justice Blackmun did the best that he could. Lastly, I wanted to point out that what is even more egregious and shocking is that Justice Alito's opinion today reaches out to reject an equal protection argument that wasn't even squarely before the court in Dobbs. And he does so relying upon the same Geduldig opinion and giving it new weight today. And in so doing, he suggests that the court is really acting in a way that is a form of judicial statesmanship. They're going to send abortion, the issue, back to the states, and that is going to be less polarizing. And I think that we're seeing today that that is definitely not true. And Alito's opinion is, in fact, even more of a polarizing influence. So I think I'm out of time.
No, you look.
Oh, I've got 30 seconds left.
Y'all are so virtuous.
So yes, so those are the comments I think that Justice Blackmun would have made on Roe versus Wade, and thank you so much. Thanks.
Okay, now we just need to have Professor Reva Siegel join us. You're going to do it from there. Do we need to shut the slides down here? No? Okay. This actually tees us up perfectly for her remarks.
So am I on? Okay, so.
You're on, Reva.
Okay, great. Thanks so much, everyone. I want to thank the Dean and Linda, Aziza, Nicole, and all the organizers for convening us. And in my remarks this morning, I'm going to be really going in not through equality first, although I'll wind up there, drawing on the concept of constitutional memory to talk about the occasion that we're marking here. By constitutional memory, I mean that constitutional interpreters all the time are making claims on our past in arguing about who we are and what we should do. And not surprisingly, when we frame it that way, we can see that constitutional memory has a politics. These claims on the past, whether in originalist or other modes of constitutional argument, whether inside or outside of courts, they legitimate the exercise of state power. And for this reason, these constitutional memory claims, no matter who's making them, they're valuated, they're interested, and whether true, false, or as most Commonly they're selective in their account of the historical record, as we'll see, and as I'm gonna unpack here. So to commemorate Roe's 50th anniversary and illustrate this concept of constitutional memory, I'm going to start this morning by suggesting how Dobbs employed selective claims about America's history and traditions to celebrate inequality as freedom. And in the last part of my remarks, I'm going to suggest how different claims on constitutional memory might mobilize critique and resistance to the vision of America that Dobbs is celebrating. And in doing this, I'm going to be drawing on two of my forthcoming papers, which Linda mentioned in the introduction. One of them on Dobbs is called Memory Games, Dobbs's Originalism as Anti-Democratic Living Constitutionalism and Some Pathways for Resistance, quite a mouthful. And the other, which I co-authored with Carrie Franklin, is called Equality Emerges as a Ground for Abortion Rights in and After Dobbs. So the conservative legal movement began its attack on Roe in the Reagan administration, where originalism began, channeling backlash to the Warren and Burger courts. And in his earliest speeches on originalism, Attorney General Meese claimed that Roe was contrary to original intention, offering as sole support, I mean sole, as in literally sole support for that claim, a quote from John Hart Ely. There was then no method or evidence to support that claim on original understanding. Nearly 4 decades later, Justice Alito, who worked in the Meese Justice Department on a brief calling for Roe's overruling, that was in the Thornburg case, wrote a Supreme Court decision that in fact overruled Roe, in which he quoted the very same line from John Hart Ely, but in Dobbs, Alito also justified overruling by appeal to the nation's asserted history and tradition of banning abortion. That constitutional memory claim depends on selectivity of several kinds. To make credible its assertion that America had a long tradition of banning abortion, Dobbs minimizes the significance of the long period at the founding and into the mid-19th century when states following the common law allowed abortion until quickening, a woman's perception of fetal movement during the 4th month of pregnancy. It was only in the mid-19th century that a newly forming American Medical Association led a campaign to ban abortion across the nation. Justice Alito's account of America's history and traditions lists in its appendix statutes enacted during this campaign, severed from historical context. A list of statutes is not a tradition in which the United States can convincingly anchor an interpretation of the Constitution's liberty guarantee. It matters why the statutes Alito lists were enacted. And so here we have Dobbs' Great Repressed. In a passage that runs on for some 5 paragraphs, Justice Alito recounts the arguments of an historian's amicus that the abortion bans were enacted for a mix of legitimate and illegitimate reasons, to protect unborn life and to enforce women's family roles and to preserve the ethno-religious character of the nation. Banning abortion would protect the unborn, enforce women's roles, and prevent ethnic replacement. This is in the 19th century. Justice Alito rejects, in the opinion, he rejects this story of mixed motives, and I quote, "Are we to believe that the laws were motivated by hostility to Catholics and women?" He asks. "There is ample evidence that the passage of these laws was instead spurred by a sincere belief that abortion kills a human being," close quote. Notice the word instead. In place of an encounter with abortion bans as first enacted, in which actors held beliefs about women and beliefs about the fetus, all of which we can assume were sincere, we have a fiction, the fiction on which the entire Dobbs opinion rests, that people who seek to ban abortion are concerned about the fetus, but hold no constitutionally relevant views about women. Women are simply a physical vessel where the fetus is. Justice Alito projects this view throughout Dobbs, and it authorizes the deprivation of women's rights, past and present. Dobbs' selective account of abortion's criminalization is ultimately more consequential than the opinion's marginalization of quickening. 19th century advocates for banning abortion argued from caste-based views of women. They argued that women existed to bear, that women existed to bear and rear children, and abortion bans were useful in enforcing these sex roles. Anti-abortion advocates mocked women's claims for suffrage and for voluntary motherhood. Contraception was first criminalized in the 1870s, think the Comstock Act, with statutes like Comstock banning distribution of abortifacients and contraceptives together. Wives who then had no rights against rape in marriage now saw their access to contraception and to abortion restricted by law. They were subject to compulsory childbearing without a vote or say in the matter. In short, the statutes in Dobbs' appendix, which appear, if we talk to Professor Aaron Tang, appear to be significantly overcounted, have been ripped out of all relevant historical context, and the story of their genesis is whitewashed. It is, in my view, terrible history and worse constitutional law for Dobbs to present the statutes in its appendix as the nation's history and tradition of liberty. The court has presented domination as freedom and encouraged Americans today to view it that way. The selectivity of Dobbs' constitutional memory is no accidental construction. It is an authorizing construction. It authorizes depriving women of rights, and it is powerful precisely because it has deep, deep roots in the Anglo-American common law. Women's inequality helped make abortion bans seem reasonable means of protecting unborn life. And it is the continuing force of these role-based views about women that makes it possible to talk about the state's interest in protecting embryos and fetuses as if embryos and fetuses were disembodied and their protection had no implications for the lives of actual living persons. Selectivity in representation, these patterns of lost, omitted, and repressed facts helps naturalize status, power, and privilege. Though women contested their lack of political authority in the constitutional order for more than 2 centuries, there is no trace of their arguments in our constitutional law. When women mobilized to demand repeal of abortion bans a century after the laws were first enacted, they had the vote, but scant access to the means of shaping law. This was in no small part because society organized motherhood as caste work. A woman who became pregnant would be expelled from school. A woman who became pregnant would be fired. A woman who became pregnant out of wedlock faced forced marriage or no marriage at all. And if a woman tried to end an unplanned pregnancy, she risked sterility or death, unless the man, a committee of doctors, agreed. Under these conditions, abortion bans could devastate women's lives. In Roe, the Burger Court responded to women's claims for emancipation, yet gave only a thin account of the reasons why abortion bans were unconstitutional. Roe was a transitional decision. The all-male court that handed down Roe had not even yet recognized that women were entitled to equal protection. Roe augured the development of that body of law. The court did recognize that women and their doctors had a right to privacy. The court simply recounted the injuries of pregnancy and asserted, in view of all this, we do not agree that by adopting one theory of life, Texas may override the rights of the pregnant woman that are at stake. In Roe, the court began to recognize woman as a different kind of legal subject than she had long been in the eyes of the law. But the justices in Dobbs cling to that earlier view of woman, and so read Roe with contempt. Dobbs's account expresses the ancient and familiar view that women exist for childbearing. If a woman exists for childbearing, then there are no rights of the pregnant woman that are at stake. Why else is the Dobbs court literally indifferent to the cascade of harms that state action coercing pregnancy inflicts on women? I refer here now not only to the opinion's discussion of the 19th century campaign, but to its dicta on equal protection and to its holding on reliance. Constitutional memory is not only an instrument for justifying repression, it can also enable critique and resistance. And so much of the history we've examined can be mobilized to anti-subordination ends. Carrie Franklin and I draw on constitutional memory to argue for what we call an anti-carceral presumption. In a gender egalitarian society, government efforts to protect potential life should look different than in a world in which the work is performed by a disfranchised caste. There are, in fact, many ways states can protect new life that are compatible with women's equal citizenship. To reduce abortion, the state can assist those who are sexually active and wish to avoid becoming parents. To protect potential life, the state can assist those who are expecting children and would become parents if they could afford to do so. These forms of state action do not target, punish, and coerce women resisting motherhood. You have here in what I'm describing the core of the equal protection amicus that Melissa Murray, Serena Mary, and I filed in Dobbs, and that Justice Alito anxiously attacked in dicta. There was no equal protection case, claim in the case before he overturned Roe. I don't have time in my 12 minutes to say so, but we showed that Godoldig had been superseded. He's trying to reinstate it. There are many states in the United States that do provide for these choice-enhancing means of reducing abortion and protecting life. But the 13 states that have rushed to criminalize abortion in the wake of Dobbs tend to be the states least likely to have pursued any of these other means of protecting potential life. Most not only employ criminal law means to protect unborn life, but do so while denying the people coerced into giving birth forms of social provision commonly offered in other United States jurisdictions. The policies, that is to say the anti-abortion bans or the abortion bans, inflict degrading and punitive treatment, typically on young, poor women, too often of color. The regimes that have resulted too often seem shaped by status-based judgments. At the same time, there are many others, legislators, judges, and voters who are speaking out in the Constitution's name, insisting that there are in fact limits on how government can coerce those who are or may become pregnant. They've appealed to liberty and to equality and to constitutional memory, to other histories that Dobbs refused to acknowledge, to understandings that gave rise to the anti-slavery movement, to the suffrage movement, to the social mobilizations that produced Roe, and to the mobilizations against sterilization abuse. I'm going to just finish up in a minute here. Recovering these voices and democratizing the sources of constitutional memory will help transform this nation's account of its history and traditions, and so provide more resources for conversations about the family we so critically need to have. The public's repudiation of Dobbs is, I think, the next stage in the struggle for reproductive justice. We're not going to go back to the world of Harry Blackmun, bless his memory, but forward into the world of the 21st century. And this anti-carceral presumption is going to look different as we argue about what is required to protect life from state to state and transnationally. As communities are debating not only the terms in which government regulates abortion, but critically, I think, the infrastructure that societies build in support of both intimate and family life. That is the conversation that Dobbs' constitutional memory claims have ignited, in no small part because this court seems to have diminished its own authority to speak for we the people in disparaging and dismantling Roe. Thank you.
Thank you, Reva. Okay, and the seamless web to our next speaker now, expert on the eugenics movement, Professor Paul Lombardo. Thank you.
Okay, thank you very much. I'm flattered to be here speaking today because I look out on the crowd and see people whose expertise in this area dwarfs my own. But I think the more important part is that there are lots of people here who are just starting this work and whose work I read every day online, on law reviews and the newspapers. And so at least I want to offer a word of encouragement to all of you. I was pleased, George, that you talked about the Blackmun 1987 event here. I happened to be there.
Yes.
I still, the picture that I managed to crib standing next to Justice Blackmun still is in my office. And actually, to be honest, I was sort of taken at that meeting at the way that at least one person did something which I thought was neat, which was to illustrate his talk with slides. That was George. So if I use them well, if I use them too much, it's on you, George. So thank you. In the time that I have today, I want to describe how anti-abortion activists in a decades-long campaign have worked to associate the term eugenics with practices such as abortion, which they oppose. This rhetorical strategy relies on the intentional misuse of history and regular repetition of false assertions about the history of both birth control and abortion. It has been successful on the legislative front in many states, and it has obviously culminated in recent Supreme Court opinions, most notably Dobbs. Eugenics is now the anti-abortion movement's favored descriptor for anything it wishes to condemn. Anti-abortion partisans use eugenics as a linguistic club, hoping to link their opponents with the horrific record of both the Nazis and those in the US who championed coercive legal strategies, whether or not their use of the word corresponds to any historical reality. This strategy relies on a false account of the attitudes of leaders of the eugenics movement towards both abortion and birth control. I want to show how that process has played out, but first a brief word about eugenics. Most of us have heard about this idea. As you've likely been told in the past, Francis Galton coined the term in 1883, eventually giving it this expansive definition. He studied hereditary intelligence and he advocated for what he called well-born babies. In the US context, eugenics in practice meant laws that allowed sterilization, prohibited interracial marriage, and imposed restrictions on immigration, among other things. The word and the politics connected to it now signal to most people a toxic mix of racism and bigotry focused on the poor and the disabled. And ultimately, the word eugenics summons images of the Holocaust. But what does this have to do with the Supreme Court? Well, the use of eugenics as a potent argument against abortion surfaced most prominently at the end of the 2019 Supreme Court term in the case of Bach versus Planned Parenthood of Indiana and Kentucky, which involved a challenge to an Indiana law that prescribed procedures for disposal of fetal remains and prohibited abortions based on race, color, sex, or potential disability. The court validated the portion of the law related to so-called fetal remains, but deferred a decision on the abortion ban in a short per curiam opinion that barely filled 2 pages. In contrast, Justice Clarence Thomas wrote a 10-page concurring opinion in which he endorsed the entire Indiana law by claiming a clear link between the legalization of abortion in the late 20th century and the beginnings of the birth control movement a full 3/4 of a century earlier. His attempt to link abortion to eugenics emphasized the role of Margaret Sanger, citing the eugenic language she used regularly, and Justice Thomas announced the foundations for legalizing abortion in America were laid during the early 20th century birth control movement, a movement that developed alongside the American eugenics movement. And so for the rest of his opinion, he restated this claim, saying many eugenicists like Sanger supported legalizing abortion. Now, that opinion was met with a resounding boos from historians who condemned Thomas' comments on eugenics as simply false. Nevertheless, 2 years later, in the now infamous opinion in Dobbs, Justice Samuel Alito cited the claim Thomas made in the Box case, somewhat more subtly, mimicking the inaccurate eugenics abortion linkage, and dropping a footnote in which he discussed the brief for the amici curiae, African-American, Hispanic, Roman Catholic, and other religious civil rights organization. And the title of that brief was "The Eugenics Era Lives On Through the Abortion Movement." That brief echoed Thomas' misguided attempts at history in Box. So I've been wondering whether it was possible to assemble some evidence that showed just exactly what people in the eugenics movement did think at that time. And it's not hard. Here's Charles Davenport, considered by everyone who writes about this the dean of the American eugenics movement. He was the founder and director of the Eugenics Record Office in Cold Spring Harbor, New York. He had been teaching at Harvard, the University of Chicago, and he had a textbook which came out the year after he started the ERO in 1911. And that textbook was called Heredity in Relation to Eugenics. And in its very first pages, it says, while the state should without question control the propagation of the mentally incompetent, no eugenist could support destruction of the unfit either before or after birth. So a very clear statement in a textbook on eugenics by the leader in the country saying he's not in favor of abortion. Harry Laughlin, really infamous as the second lieutenant of Davenport's, he shared the aversion that Davenport had both to birth control and to abortion. It would really be hard to find a person so publicly linked to the most intolerant and vile policy initiatives of the eugenics cause than Laughlin. He's famous for his model sterilization law, his congressional testimony on immigration restriction, his advocacy for prohibitions on interracial marriage, and not incidentally, his honorary medical degree, which he received in 1936 from the Nazis. Hard to make this stuff up. Laughlin's policy brief, legal, legislative, and administrative aspects of sterilization, emphasized the focus of organized eugenics, and he said, preventing the procreation of defectives rather than destroying them before birth or in infancy or in the later periods of life must be the aim of modern eugenics. He was clearly and publicly against abortion. He later applauded the pro-natalist Nazi program, also outlawing abortion. So those are the two major leaders in America. Here's a third. This is the comment from Laughlin's book. A third person, which you recognize as the king of cornflakes, John Harvey Kellogg. He was the founder of the president of the Race Betterment Foundation in Battle Creek, national conferences there 3 times, 1914, 15, and 25. And his eugenic sentiments were clear. He demanded we must prevent multiplication of defects by the unfit by recognizing the law of eugenics. He too wrote more than a few books. And in this one, which was published in 1917, called Plain Facts, his thoughts on abortion were made clear. He said, of all the sins, physical and moral, against man and God, I know of none so utterly to be condemned as the very common one of the destruction of the child while yet in the womb of the mother. In that same book, he equated infanticide and abortion, saying, there is in fact no moment after conception when it can be said that the child has not life. And the crime of destroying the own life is as heinous as sure before the period of quickening has been attained as afterward. So there you have Davenport, Laughlin, and Kellogg, recognized leaders of the eugenics movement in the United States, all of them saying they're against abortion. You can find many, many other people. Here are just 3 more: Ellsworth Huntington, Irving Fisher, and Harvey Jordan, all leaders, all office holders in the eugenics movement. There are dozens more. In fact, after looking at this topic for decades, I have been unable to find any leaders of the eugenics movement before 1915 who supported abortion. So I understand that it may be attempting to just dismiss the historical point I am making as some kind of antiquarian fetish. I'm used to that part. I'm explicating these obscure details of Supreme Court footnotes, but consider for a moment how successful the false eugenics equals abortion argument has been. The so-called reason-based laws, like the Indiana law challenged in Box, prohibit abortions that are motivated by race, sex, or potential disability of the fetus. And to the extent they invoke eugenics as the evil they wish to avoid, they rest on that same lie. At the same time, at the time of the Dobbs opinion, proposed anti-eugenics laws had been introduced in 41 states, and I'm relying on my colleague Sonia Suter here, who has an article which will detail this in much more articulately than I'm going to, pointing out the laws that are in place right now. That'll be coming out soon. 20 states have actually adopted these laws. The Dobbs decision opened the door for much more expansive state prohibitions on abortion for any reason at all, but we should expect reanimation and further litigation about the so-called reason-based bans, particularly in states where recent and more extensive prohibitions are extensively challenged. There is more than a little irony in how abortion opponents are trying to use eugenics. I would note that in Roe versus Wade, the very case that overturned abortion laws and was itself overturned in Dobbs, when it was decided, as most of you know, there was a companion case called Doe versus Bolton. And the Georgia law struck down in Doe included a very specific eugenic provision, as you can see here. Had Roe never been decided and its companion Doe not have occurred, the eugenic abortion provisions of Georgia law would have remained in place today. There were no anti-eugenics arguments made by Georgia lawyers supporting the law challenged in Doe. So this brings us to, today. I want to summarize. Mainstream supporters of eugenics condemned abortion generally, even while they disagree about how useful birth control could be to the eugenic goals they supported. They understood that opponents of both birth control and abortion were playing upon public ignorance to erase the distinction between preventing conception and ending pregnancies. Justice Thomas and his colleagues are repeating the strategy of confusing abortion and birth control in a campaign that would ultimately abolish both practices. This rhetoric also points the way toward banning birth control, a goal that Justice Thomas has already signaled with his comments on Griswold and the Dobbs concurrence. Part of repurposing of the term eugenics is clearly pointed toward that goal. But even authentic disgust at the atrocities perpetrated by supporters of eugenics does not justify intentional falsification of the historical record. At the very least, Supreme Court opinions that strip long-established rights from the majority of citizens should not be founded on a false account of the past. And we should recognize that the position of so-called pro-life abortion opponents is not a repudiation of eugenics, but a repetition of the same sentiments that were uniformly held among eugenic leaders a year ago. Thank you.
Thank you. Perfect. Okay, we're going to take questions from the in-person audience, and then Elizabeth is going to help me tend the virtual audience comments as well. So let's start with anyone. Does anyone on the panel want to say anything to each other before we turn it over? Oh, yeah, if you'd like to. I mean, no pressure, but if anyone, since there are some interconnections among the, can we put Reva back on the screen? Is that possible?
Yeah.
Yeah, let's just put Professor Siegel back on the screen as well.
So Reva, I loved your presentation. Hopefully you're still with us.
I'm here.
The statements about Justice Alito's statutes, that incredible list of statutes at the end, which is, as you said so beautifully, neither history nor constitutional law. And I just wanted to comment that Justice Blackmun, of course, in his history, had looked at the historical evidence at the founding and had focused very much upon the fact that abortion was not criminalized during the founding of the Constitution and prior to quickening. And Justice Alito dismisses all of that historical evidence and then juxtaposes or substitutes his own statutes of 1868, which he suggests were much more relevant. And so thank you for pointing out that those statutes, as Justice Blackmun had explained back in Roe, were enacted as part of a medical movement to kind of medicalize the issue. And so the reasons for the enactment of many of those statutes are as important as the fact that they exist, but also this whole question of when to look to history and tradition, and whether 1868 is more relevant than the framing of the Constitution. That dispute existed in Roe itself. And Justice Alito says, you know, we should settle upon 1868 and the 14th Amendment as the point at which history and tradition becomes important. So I wondered if you had any comments on that question.
Well, thanks. The first thing I would say is to notice how much in all of our constitutional law claims on the past, whether as a source of wrongdoing or a source of a tradition that can guide us, actually play an enormously significant role under different bodies of law. In Roe, that record was evaluated differently than it is being evaluated in Dobbs. In fact, the first thing we should notice is that, I'll just say very briefly, that the majority in Dobbs changed the governing law that guides the evaluation of history and traditions, essentially taking the dissenter's point of view in the marriage cases and getting rid of the law that Justice Kennedy had developed. And the Glucksberg standard that now governs is very, very unclear about how you identify and evaluate a tradition. And that's going to be in play over all of these other areas of law that have been impugned by Dobbs. So in fact, there is not a very clear standard, even though they say it constrains judicial discretion, it actually just conceals judicial discretion. So they've cherry-picked their record here. The simplest thing to say about this record is that, like the record in Bowers versus Hardwick, that was essentially criticized and ultimately repudiated in Lawrence, this record deserves our attention. It is, in some respects, an account of the facts, and in other respects, a framing of the facts that contains omissions and actually errors. It's interesting, people might look at Aaron Tang's new piece that's forthcoming in Stanford. There may be miscountings of the statutes, etc. It's extremely, I don't want to take the group's time, but I do want to highlight that people should not defer to the claim that we are an abortion banning people. The last thing that you might catch in my remarks toward the end, I was being as concise as I could, is that there is no reason that we should defer to a list of statutes. There is no reason that we should defer simply to laws passed by a narrow group of the whole polity. There were many people who couldn't participate in that lawmaking, and a tradition can draw on expressions of norms by those who are not authorized to make law. And when you expand the scope in that way, as Peggy Cooper Davis reminded us, you can look to the traditions of those who resisted slavery and those who sought suffrage and the voices of many others in saying who we are as a liberty-loving people. So I'll stop right there.
Thank you, Reva. I have one question from the virtual audience, and it's from Trine Soteros to Professor Lombardo. Can you talk a little more about the origins of Justice Thomas's connection between eugenics and abortion?
Yes, well, it would take a while, but I think that a conscientious look at a series of cases going all the way back to the early 1990s shows this word, which I have a peculiar attention to, showing up quite early in briefs. The so-called assisted suicide cases, the briefs in that case, various briefs that come up in cases like Baby K, the use of this word as a pejorative to tag behaviors that you disapprove of has a long tail to it. It would be, I think, accurate to say that if you traced and did a sociogram of all the people who made this contribution, the single thing that comes out most clearly over time is that this is a long-term project of the Federalist Society.
Okay. Yeah, Jessica, Professor Silby.
Yeah, hi. Jessica Silby. I teach here in the law school, constitutional law. Thanks for a fabulous panel. So my question has to do with, so I really appreciate the recontextualization or talking about this as selective memory or misuse of history. I think Reva called it fiction at one point, and there's no one said they're lying. No one said anybody's lying or there's a willful disregard for the truth. But I think we can accept that there is such a willful disregard for the truth, that all these are ways of being nice about just not talking about facts that we know to be true. And so this is my question about strategy and politics, but I'll admit it's also selfish because I struggle to teach constitutional law over the 20 years I've been doing it, which is, it seems to me that so much of constitutional law is based in selective memory and willful disregard for lots of truths that exist. And so faced with this moment, with this particular case, I wonder, how is this different from other times in our history when this has happened, if it is at all? And is there a new way to attack this problem today, given that we are in a different place than we were in other decades, given that I think these are similar problems that we've seen, battles of narratives, disregard of facts, et cetera. So those are I know, very big questions, but I have pleas to you to answer them.
Anyone? I know Reva has probably something to say, but does anyone from this group?
I don't see this. I did use the word lie because that's what I think it is. I don't see this. I agree with you that if you spend your time reading not just Supreme Court opinions, but any opinions, you're always looking at a selective choice of facts and arguments, right? The side that wins, if you go back and dig up briefs, you realize, wow, that's funny. They said that in their brief. That's not a chance event. I could go on at length about how we do that kind of recreation of reality in cases, and I've spent probably more time than I need to talking about that in other papers, but I don't think it's different. I think it's more bold now. I think it's more straightforward in your face now. And I think that the only way we can counter it is the way that we're trying to counter it right now, which is to call it out.
Anyone else on the panel want to address that? Reba, do you want to add anything?
Well, I'll just say very briefly that there are certain things that I said today that are pretty direct and accusatory. And I don't know what a legal fiction is as distinct from a lie, but there are. I think that what is critical to do with this opinion is not just to call it names, but to pick out how it creates frames that make what's going down look reasonable, and to make those frames legible, and to go after what's completely wrong about them and how reframing it enables action. And that's what I'm trying to do here, both the way in which memory licenses domination and the way in which memory licenses resistance. That's the way in which I've tried to organize this. And it didn't just come to me. I woke up and I said, I've been wrestling with this material to get it to that point. If I had more time and I'm self-conscious about not wanting to take it, I would go back into what I said and unpack that. But I'll just say that that's the place that I led rather than just calling names. I wanted to organize what I was observing about the opinion in a way that would enable action. And when I say enable action, I mean, most of all, when I'm speaking, for example, with my students, they're coming up in a world in which they're facing this court. And the question is, what is it that they can do? And everything on my mind is organized around the form of what is it that we can do? When we did our panel here the other night, everything was along that axis. And I consider this both a disaster and a massive opportunity. There was much about the world of Roe circa 5 years ago in which people were arguing in a very constricted field of action, and blowing up that whole frame, while it's a massive loss and while it's going to suggest large, untold numbers of people to abusive action in circumstances where democratic response is illegitimately restricted, it is nonetheless, because we're stuck in that situation, an opportunity to rework what it means to call for reproductive justice, and to do so in legislative arenas and in different state courts, purple and blue state courts, where the frames can be expressed in 21st century terms more capaciously and in new ways. And as I was saying to some of our students last night, we can look back to the world before Roe and see how much more ambitious and wide-ranging the claims originally were, and go back to where we stand today and imagine a world way more capacious than the one we were arguing in even 5 years ago. So I don't imagine it to be all loss. I imagine it to be the form of social conflict, and everything is dynamic. There's loss, there's opportunity.
Hey, why don't we go ahead and get started, if everybody wouldn't mind to take your seat. Thank you. So this is panel 2, the impact of Dobbs on medical practice and reproductive health care. We have a really exciting lineup of experts in medicine, law, public health, and bioethics to explore the impact of Dobbs on medical education and reproductive health care. We'll start with Dr. Amarilla Pasha, who is a DO and JD, someone using his entire brain. He's an assistant professor of medicine in the Division of General Internal Medicine at the Mayo Clinic in Rochester, Minnesota. His research focuses on health law and policy with special emphasis on FDA law and health policy education for clinicians. He's the editor of the recently published book titled Laws of Medicine, Core Legal Aspects for the Healthcare Professional. And he'll be joined during the Q&A by his co-author, Dr. Daniel Breitkopf, who's an associate professor of obstetrics and gynecology at the Mayo Clinic as well. He's the department chair of obstetrics and gynecology. His academic career has been devoted to teaching the next generation of OBGYNs and conducting clinically relevant research. Dr. Breitkopf is an editorial member of the board member, for the Journal of Minimally Invasive Gynecology, sits on the board of directors of the American College of Obstetricians and Gynecologists, and serves as an oral examiner for the American Board of OBGYN. Professor Nadia Sawicki is the Georgia Reithel Professor of Law at Loyola University, Chicago, and co-director of Loyola's Beasley Institute for Health on Policy. Her research focuses on patient decision-making and the informed consent process, particularly in the areas of end-of-life and reproductive care. Nadia is joined by co-author Liz Kukura, who's assistant professor of law at Drexel Klein School of Law. Her research falls at the intersection of health law and gender with a particular focus on legal issues related to pregnancy and childbirth. We're especially grateful for Nadia's presence because she's going to have to step out a couple minutes early to remotely teach a course while she's here today. So that's dedication. We have Dr. Yvette Cozier, who is Associate Dean for Diversity, Equity, Inclusion, and Justice and Associate Professor of Epidemiology at BUSPH, where she's an investigator on the Black Women's Health Study. Her research interests include social and genetic determinants of health in African-American women, specifically the influence of psychosocial stressors and genetics in the development of diseases. We also have Professor David Cohen, Professor of Law at Drexel University Klein School of Law, where he teaches constitutional law, sex discrimination in the law, and reproductive rights and justice. He's co-author of 2 books about abortion, Living in the Crosshairs, The Untold Stories of Anti-Abortion Terrorism, and Obstacle Course, The Everyday Struggle to Get an Abortion in America. He's on the board of the Abortion Care Network and works in the Women's Law Project representing abortion providers in Pennsylvania. With Greer Donnelly and Rachel Reboucher, who are joining us later today, he has spearheaded adoption of shield provisions in abortion-supportive states, laws that protect abortion providers and patients from anti-abortion state efforts to punish them. Finally, we have Dean Judy Darr, Ambassador Patricia L. Herbold, Dean and Professor of Law at Northern Kentucky University Salmon P. Chase School of Law. Dean Darr published the first casebook in the field of assisted reproductive technologies, conveniently called Reproductive Technologies and the Law. The 3rd edition is underway. And among many other publications, her most recent book, The New Eugenics, Selective Breeding in an Era of Reproductive Technologies, was published in 2017 with Yale University Press. Thank you to all of you for being here today. Dr. Pasha, take it away.
Perfect. Thank you for having me here, part of this distinguished panel and part of this program. I'm thrilled to be here. Before I get started, I do want to point out that I do work for Mayo Clinic, professional home of Justice Blackmun, but if any opinions expressed here are my personal opinions and not that of Mayo Clinic. So with that, we can get started. Our paper is really about the effects of Dobbs' decision on physician workforce and graduate medical education. Beyond the direct effects of Dobbs on patient care and clinical care, we also have to assess and consider the indirect impacts of Dobbs on patients and clinicians. And in particular, our area of focus was on physician workforce and graduate medical education. The biggest takeaway I hope that you take away from our talk and our work is that this is a national issue. It's not going to be just on restricted states, but it's going to affect every state, because once you have a physician workforce issue are national issues. And if you have a shortage in one area, you're going to have a shortage in other regions as well. So for example, if we have a shortage in subspecialists trained in complex family planning or maternal fetal medicine subspecialists, that's going to be felt in restricted states such as Alabama and Mississippi, but it's also going to be felt in protective states such as California and New York and others. So we have to keep that in mind, and we have to work collectively to address these issues to prevent these concerns to affect patient care. When analyzing physician workforce and graduate medical education, you have to always analyze it from two different perspectives. One is the perspective of the training program, and the second is the perspective of the trainee. From the training program's perspective, their goal is to meet training standards and educate physicians that are competent and future leaders of the field, in this case, OBGYN. We have seen pre-Roe, as states were liberalizing their abortion access state by state, that there was a shortage of a physician workforce that were properly trained and competent in providing these services. And as a result, we saw a skyrocketing of complications because we just didn't have the adequate workforce to address these needs. And we might see that again if we don't address it now and make sure that we have adequate workforce for the future. Because I think somebody mentioned on the panel that the future is pro-choice. So we have to make sure that we secure that access by providing adequate physician workforce. And from the trainee perspective, when you think about a medical student who's trying to choose their residency, or a resident who's trying to choose their subspecialty, their fellowship, if they're choosing between 1, 2, 3, 4 different fields, and maybe their preferred field is potentially banned in half of the country, that will give them second thoughts, right? Do I really want to go into that? Do I want to deal with all the complications that cause this, where I can just go to my second preferred specialty or subspecialty and not have to deal with these complications? And this is not just about abortion. It also involves contraception, assisted reproductive technology, and really any subspecialty that involves procedures that increase the risk of fetal loss will be impacted by this decision. So it really goes beyond abortion. And we've already seen, and my colleagues on this panel will discuss laws such as the Utah law, which will really affect assisted reproductive technology and so on. So our work, we really focus on 4 areas on this issue. One is to assess and analyze the effect of Dobbs on clinical training in abortion and other reproductive health services. We suggest practical solutions to alter relevant training standards and recommend ways to protect trainees and training program from government action. And lastly, we propose steps to minimize the national effect of the national impact and negative consequences of the decision on physician workforce. And I'd like to share some of them with you. So the Dobbs decision has already affected accreditation standards and training requirements. The ACGME, the Accreditation Council for Graduate Medical Education, which is the accrediting body for graduate medical education, residency, and fellowship programs in this country, requires that all OBGYN residencies provide training in all forms of contraception and at minimum access to abortion training. Obviously, that access to abortion training has greatly been impacted since the Dobbs decision. And some estimates have shown that 44% of the 286 residency programs in OBGYN are now in states that or jurisdictions that either have already limited or will soon limit access to abortion. This is in contrast to the pre-Dobbs era, where 92% of OBGYN residents had access to abortion training in their home institution, not just their state, their home institution. And that has already obviously been changed. ACGME has updated its program requirements for OBGYN residencies to specifically state that in jurisdictions where resident access to clinical experience is unlawful, those programs are required now to provide access to clinical experience in a different jurisdiction where it is lawful. The only way to do that is to send your trainees out of state. And this will impact training for the trainees from restrictive states, but also trainees in protective states, because now we have the pool of procedures in protective states probably gone up a little bit, but not enough to satisfy the move from all the trainees from restrictive states to the protective states. So this will impact all resident education, all their clinical skills and all their clinical competence. But even ignoring this oversaturation issue, just the fact, the physical, emotional, and financial burden on trainees that now have to move from one state to another to seek training should be considered and will be considered by these trainees when they're making choices about their future and their profession. And lastly, I will point out that although the focus of our work is on OBGYN, this will also impact family medicine training, because they also provide some training with regards to termination, and to a lesser extent internal medicine and pediatrics because of potential effects on contraception. So how can this issue of training be remedied? Well, we have to allow for simulation training and didactic sessions to play a bigger role in training. And we already use simulation training in OBGYN programs and other programs for that matter to train folks on more of the rarer procedures. But we have to allow this to be a more central role. It will not replace clinical hands-on training, but it can supplement clinical hands-on training when their opportunities are limited. And especially now with virtual reality and AI and all sorts of other technologies that are available, this is a great opportunity to be used. So this responsibility falls both on training programs and education leaders within OBGYN, but also on accrediting agencies and states. Training programs and education leaders really need to come up with better simulation and more robust simulation programs to allow this to take place and supplement clinical training that will be limited now. And states as well as accrediting bodies need to allow for this change to happen and allow simulation to take a more central place in central role in residency training. But also protective states really need to step up their support for this kind of training and training OBGYNs and reproductive health specialists in general, whether that's through grants or other kinds of funding, or just by regulatory flexibilities. What do I mean by regulatory flexibilities? So one area that's in need of acute attention is medical licensure. If COVID-19 pandemic proved anything, was that you can practice across state line without being licensed, and it will probably not affect medical care that much. So we need to have those flexibilities reinstated beyond the pandemic for training OBGYN residents where they have to move from one state to another to get that training. We also have to have more flexibility from the federal government, specifically CMS. During the pandemic, CMS showed great flexibility by allowing, being more flexible with their GME affiliation agreements and removing some of the restrictions and requirements. We need to extend those so these affiliation agreements can be made much easier and much quicker with less red tape, especially again for training in reproductive health. Another area to consider is out-of-state discipline. So as we move forward to an era where same medical procedure is legal in one state and illegal in another state, undoubtedly some of these restrictive states will move forward to sanction some of the physicians and their licenses for providing care that is considered standard medical care. States and relevant federal agencies should provide flexibilities and protections for licensees. So if they are sanctioned by an out-of-state entity, it will not affect them in the protective states. They have to some extent done that through executive orders, but the problem with executive orders are that they're executive orders and subject to revocation and revision with the next administration. Moreover, even if they're not revoked or revised, the thing to consider is what's the burden on the licensee to prove that they fall under the exemption when they are sanctioned by another state? How much administrative and financial burden will it take for the licensee to prove that what they are sanctioned for is actually standard care, standard medical care? And how is that achieved? So it hasn't been tested because there are not many cases to know that, but that is something to be considered as we move forward in this era. This should be ideally automatic, where the burden on licensee is minimized. And one way to do that is through the Federation of State Medical Boards, the FSMB, who is responsible for sharing data on physician licensure and sanction from other states. And maybe they could play a more central role, a more active role beyond their passive sharing of information to designate and classify these out-of-state sanctions as to whether they are part of standard care or something that is more egregious that needs more attention from other states as well. So just to summarize, in the coming years, as training opportunities are going to vanish, it will potentially lead to a decline in clinical skills, knowledge, and experience in provision of abortion and other healthcare, reproductive healthcare services. And if history is any indication, the rate of complication and maternal mortality are likely to rise unless we act now and act collectively to address these issues. And I hope this is the start of the conversation to do exactly that. Thank you.
Good morning, everybody. I'm so glad to be with you all today, and I wanted to say a huge thank you to all of the organizers for bringing us together for these important conversations. So among the many far-reaching implications of Dobbs, Nadia and I share a concern about the impact on medical decision-making of pregnant patients, and in particular, the erosion or further erosion of patients' autonomy. So I'm going to start with a quick overview of the problem and then pass the baton to Nadia to talk a little bit about the relationship between pregnant patients' medical decision-making and the legal framework in Dobbs. And then I'll finish up with some suggestions about where we might look for autonomy protections in a post-Dobbs world. So there are at least two different ways that Dobbs is likely to limit the autonomy of pregnant patients to make decisions about their own medical care. First, it's likely that some providers will believe that Dobbs provides greater justification for overriding a pregnant patient's refusal of medical treatment, where medical treatment might benefit the fetus but poses risks to the pregnant person. This commonly arises in situations where the patient and physician disagree about the use of a particular medical intervention to expedite or manage labor, something like labor induction or cesarean delivery. And generally, these are situations where the patient and provider weigh the risks and benefits of a proposed treatment differently, but rather than defer to the patient's exercise of personal autonomy, the provider invokes the state's interest in potential fetal life to justify overriding the patient's refusal of treatment. Second, it's likely that some providers will rely on Dobbs to prevent patients from receiving care that is likely to benefit their health, but could involve risk to the fetus. So the concern is that pregnant patients will be denied treatment in various areas of medical care, ranging from cancer treatment to addiction medicine, and potentially all forms of treatment involving x-rays or anesthesia, even dental care, due to concerns about a potential impact of such treatment on the fetus. And this includes situations where there's an unfounded perception of fetal risk, which is a rather large category given how little clinical research involves pregnant women and how much medical uncertainty that leaves. So finally, I'll just say in both of these categories, it's possible that providers will not simply feel emboldened by Dobbs, if they so wish, to require or to deny certain forms of care to pregnant patients, but that some healthcare providers will mistakenly perceive that Dobbs actually requires them to provide or withhold certain treatment out of concern for fetal well-being, when in fact Dobbs imposes no such requirement. So passing the baton.
Thank you so much. So I'd like to give a little bit of historical background, and I want to first give credit to Professor Margot Kaplan, who wrote about this issue over a decade ago. She offered a compelling argument as to why abortion jurisprudence should not play a role in decisions about healthcare decision-making during pregnancy. I don't have time to address these arguments in full today, but I'll note that there are many reasons why the link between abortion jurisprudence and decision-making during pregnancy is an imperfect one. Nevertheless, many courts that have authorized involuntary treatment of pregnant patients, and that's what I'll be focusing on here, have relied on the principles established in Roe and Casey to support their decisions. And I want to highlight briefly just a few of these so you understand how they've arisen. So first, here's just a sampling of cases. In each of these, the patient refused cesarean surgery on the basis of their religious beliefs, and a court overrode that refusal, holding that after the point of viability, the state has the power to restrict a pregnant patient's freedom of choice with respect to their bodily integrity. Even some courts that have rejected compelled treatment have relied on that viability line from the abortion cases to support their decisions. So here in Burton versus State, an appellate court reversed an order compelling a pregnant patient to submit to any medical treatment deemed necessary, and held that the intervention wasn't justified because the state had not demonstrated evidence of viability in this instance. And in a very recent case challenging a pregnancy exclusion in an advance directive law, an Idaho court rejected the law in part on the grounds that it restricted patients' choices pre-viability, again, focusing on that viability line established in abortion cases in a very different context. Finally, I want to note that Roe and Casey's language has been used by some courts to compel treatment even prior to viability. In this case, Jamaica Hospital, the court recognized that viability is the point at which a state's interest becomes compelling in abortion cases, but it held that even midterm, even at 18 weeks, the state has a, quote, highly significant interest in protecting fetal life that outweighs the pregnant patient's right to refuse a blood transfusion. So I'd like to talk briefly about the implications after Dobbs. Obviously, the decision in Dobbs strengthens states' arguments about fetal rights that is likely going to further restrict patients' rights to make autonomous decisions during pregnancy outside the context of abortion. So as we know, Dobbs reversed Roe and Casey, finding that the Constitution does not protect a patient's right to terminate pregnancy. And in distinguishing the abortion right from other substantive due process rights, although Justice Thomas would disagree, it emphasized that only abortion destroys a potential life. So by centering the interest in protecting fetal life, so notably in Dobbs, we're arguing that the court set a dangerous precedent for cases when patients are refusing treatment that is recommended to reduce fetal risk. So I'd like to highlight 3 important points that might be overlooked when we're considering how Dobbs is likely to impact these treatment decision cases. So first, this is not just a red state and a blue state issue. The Dobbs decision reverberates nationwide, right? Even in states with greater abortion access, courts are going to be bounded by the principle that pregnant persons have limited due process rights, at least under federal constitutional law, to make choices about their bodies, and that the state's interest in protecting fetal life can take priority over a patient's wishes, extending that reasoning to non-abortion circumstances. Secondly, the Dobbs decision is likely going to increase the number of pregnancies carried to term, which will likewise increase the number of complex pregnancies that are carried to term, where these kinds of difficult medical decisions need to be made. And for some conditions that may not be identified until after the point of viability, until later in pregnancy, this lack of abortion access is going to become even more significant. And finally, it's important to recognize that the burdens of compelled treatment in these cases are likely to fall disproportionately on patients of color. So studies of birthing experiences in the United States have found that patients of color experience more mistreatment, more coercion, and more obstetric violence, especially in situations when they are declining treatment recommended by a healthcare provider. And so as a result, it's likely that requests for legal intervention will likely have a disproportionate impact as well. With that, I'll turn it over to Liz to offer some solutions.
So Dobbs shifts the baseline of legal protections for health and safety during pregnancy. But law is not the only source of autonomy protections, right? Providers are also bound by medical ethics in the care that they provide. And so one of the implications of Dobbs is that with fewer protections for patients to make fewer legal protections for patients to make their own decisions, the responsibility will fall to healthcare providers to use the framework provided by medical ethics to maintain and promote respect for patient autonomy. So what might this look like on the ground? Well, medical ethics recognize that patients have an interest in making independent decisions about their medical care that are intentional, that are with substantial understanding, and free from controlling influences. Ethical guidance from ACOG, the American College of Obstetricians and Gynecologists, recognizes that pregnancy is not an exception to the principle that patients can refuse treatment, even when that treatment is considered necessary to maintain life. ACOG opposes coerced medical intervention for pregnancy, during pregnancy, including court-ordered treatment, both as an ethical matter and out of concern that resort to coercion of this sort deters people from seeking prenatal and other forms of healthcare. Great. So ACOG's guidance to clinicians spells out the distinction between having beneficence motivations toward the fetus and beneficence-based obligations to the pregnant woman who's the patient being cared for. And this is especially important given the mindset of many obstetric providers, both historically and today, that they have duties to two patients, which can obscure the fact that interventions on behalf of the fetus necessarily entail interventions on a pregnant person's body and thus always raise autonomy concerns. So looking at the future of autonomy protections for pregnant patients, we need professional medical organizations and specialty associations to reaffirm their commitment to respect for the autonomy of all patients, including pregnant patients. This includes, but is not limited to, groups focused on oncology, medication, emergency medicine, and anesthesia. They should oppose clinical practices that withhold otherwise recommended treatment because it poses or may pose a risk to the fetus, as well as those practices that would compel treatment for the benefit of the fetus. In doing so, professional guidance should directly address the significance of medical uncertainty that results both from big gaps in knowledge about how certain treatment may affect the fetus, and also just from the inherently unpredictable nature of childbirth itself. This means that patients must be counseled on the potential risks and benefits with accurate disclosure of what is known and what is unknown, and then be able to make decisions based on that information as informed by their own values and relational interests. So by making it explicit that it's often impossible to know for sure when a situation will cause harm to a fetus, such professional guidance would also bolster protection for physicians practicing in abortion restrictive jurisdictions by showing how medical treatment during pregnancy is different from abortion procedures and thus should not be limited by Dobbs. Finally, so in addition to professional guidance articulating and reaffirming respect for pregnant patients' autonomy, providers need specific guidance from ACOG on navigating treatment refusals after Dobbs. And then two final considerations that I'll just mention very quickly. Commitment to autonomy of pregnant patients, and specifically this idea that pregnancy is not an exception to autonomy protections, needs to be introduced early in medical education. And then we also need medical professionals who serve on state medical boards to support and enforce regulations that authorize disciplinary actions against physicians who violate these ethical norms. Thanks a lot.
Morning. Thank you so much for having me here. So I'm not a lawyer. I represent public health and research in Black women's health. So my perspective will certainly align with others, but come from a slightly different angle. So just first to say that, I am an investigator on the Black women's health study. I'm not going to talk extensively about that, but I will say that the study began in 1995, and the goal was to explore the gaps in understanding of Black women's health. And the realization, yet uninvestigated, was that Black women carry a greater burden of almost every major illness compared to their white counterparts. Yet there had been no real systematic research to address this. Certainly, we have studied within the Black women's health study reproductive outcomes, and certainly preterm birth, uterine fibroids, and hysterectomy rates. We've also studied extensively chronic conditions such as type 2 diabetes, hypertension, and obesity. And I mention those because I will sort of sprinkle some of that within this presentation, as these certainly have a role in reproductive outcomes. But first, I just want to back up and talk about how I've kind of viewed what I wanted to say to you today. And I want to relate to you a story of an experience I had back in May. I had just gotten off of a flight from Boston to San Francisco for a conference, and I had this wonderful young man as an Uber driver. And I arrived on a day of the Beta Breakers road race, so traffic was big, and So I ended up being in the Uber a lot longer than I had really wanted to be, right? So it forced conversation between me and this Uber driver. Again, very nice young man. I don't quite know how the topic came up, but somehow we ended up talking about the pending decision of the Supreme Court. And he asked a question. He said, "Is it really that hard for women to carry a pregnancy?" Yes. So I'm in the car, okay? I obviously can't I can't walk to the hotel. We're stuck in traffic. And up until now, it had been a lovely ride. And so I believe I responded to him with words about, well, if we really need to talk more broadly about our healthcare system, and maybe from there we could have a better conversation. And I was kind of ended that, and we got off into another topic. This still stuck with me. Okay, so obviously I'm bringing this up to you. And so I think every time I remember this situation, I think, what would I have told him if I had more time? What kind of conversation could we have had? So is it really hard for women to carry pregnancies? Well, we really have to think back. And as a Black woman, I look through the lens of my history, and I would have told him that Black women have had a very complicated medical history around birthing. We have run the gamut from forced reproduction to forced sterilization in this country in less than, in the last, since 1619. Forced reproduction, of course, happened during slavery, when Black women were tasked to supply the very workforce of the system that took away their humanity. Their condition passed on to their children, so their children were not fully human either, and their children were not their own. So they had this unique task. During slavery, as medical gynecological techniques were being developed, James Marion Sims, who is known as the father of gynecology and still prevalent in all of the medical textbooks, believed that Black women did not feel pain. And this myth persists today. And he used Black women, slaves, to perfect his vasovaginal fistula technique, and did so without anesthesia. When he operated on the white women, he gave them whatever was available to try to dull the pain. He didn't believe Black women suffered pain. Another physician, Dr. Francois Prevost from Louisiana, owned female slaves for the sole purpose of practicing cesarean sections and perfecting them. Okay. When we move forward a bit into the Jim Crow era, there was the Virginia Sterilization Act of 1924 that allowed for the involuntary sterilization of individuals. This was upheld by the Supreme Court in 1927, and between 1924 and 1979, it was estimated that 7,000 people were sterilized. During this same period, civil rights activist Fannie Lou Hamer spoke of her own experience in having a Mississippi appendectomy, in which a person, usually a Black woman, could be told by a physician that she needed her appendix removed, and instead, or in addition to the appendix, her uterus disappeared in that same time. So these are, some of the things that I might have brought up to him. Now, I don't want to leave the impression that it was only the southern states that did this. There was certainly evidence that this was happening at teaching hospitals in the Northeast, in which poor Black and Puerto Rican women received unnecessary procedures. The Southern Poverty Law Center in 1974 filed a class action lawsuit on behalf of two sisters, ages 12 and 14, who were sterilized by a federally funded program through the Montgomery Community Agency. This lawsuit revealed that up to 150,000 women had been sterilized using federal funding through these federal centers. Half of these women were Black, and at that time, they would have accounted for about 6 to 7% of the US population, yet they made up 50% of the sterilizations. So in the Black Women's Health Study, we have looked at hysterectomy, and we found in our population of 59,000 women who are from across the United States that hysterectomy was associated with low education, having 12 or fewer years of education, having one's first birth at less than 20 years old, so usually teen mothers, and living in the South. Okay? So this certainly supports this narrative. In terms of the burden of reproduction, in 2020, the US maternal mortality rate was 24 deaths per 100,000 live births. It may not seem like a big number, but this is more than 3 times of what is observed in other developed countries. So it is fair to say that the US is a dangerous place to give birth in the developed world. When we tear this number apart further by race, we see that for Black women, they experience about 55 deaths per 100,000 compared to 19 per 100,000 among white women. And this discrepancy, this disparity exists even after controlling for income, education, and access to care. So this is a systemic problem that needs to be addressed. There are some medical and social factors at work. Medically, chronic illness is something that our data in Black Women's Health Study have shown. Black women tend to experience cardiometabolic conditions such as hypertension, type 2 diabetes, and obesity at higher rates than white women, and they develop these conditions at least a decade earlier, so that they're more likely to occur during the reproductive years. However, we have also found that these conditions are not necessarily genetic, but they are based on or related to neighborhood and community factors, such as historic segregation and redlining, the hypersegregation that leads to Black women with higher education still living in under-resourced neighborhoods where a full-service grocery store may not be available, where green space and recreational space may not be available either, and lead to higher rates of these conditions. This also speaks to the availability of preventive care. And we have to note that the Affordable Care Act, came about through the expansion of Medicaid, was rejected, and it continues to be rejected in at least 14 states. And many of these states are in the South, and many of these states are the same states that are most enthusiastic about taking away abortion and other healthcare rights from women. The other side of what could be contributing to this high mortality discrepancy is a phenomena of racial devaluation. And that is where women who are not heard by their clinicians, and this not hearing and recognizing their voices, their pain, their distress leads to their healthcare being compromised, and the threat of death is always present in the birthing process. So then what happens after Roe? Will Black women continue to die at higher numbers? And I'm leaving these questions out there. Or will they increasingly experience Mississippi appendectomies? We know that uterine fibroids, something that we've also found within the Black Women's Health Study, contribute to pregnancy losses. So will Black women be criminalized when they come in with a miscarriage forced by a condition in their womb? What will happen to their children? And so when I come back to end on this Uber driver, a question I would ask him, because I've thought of it now, and I think of it, and I give him the benefit of the doubt, maybe he is asking a sincere question. But as a young man, I would ask, when do you take on the burden of reproduction? When will, is it okay if we start charging child support at conception? Possibility, right? Or, when will we develop male contraceptives? Right? This country has not had a male contraceptive reach phase 3 of a clinical trial. There's one currently in phase 2B. So they're going to probably go down the alphabet before it can ever get to phase 3. And then how do we acculturate young boys of today? How are we going to shape them to think about the reproductive process and their role in this? And we have that opportunity, regardless of where we go after Roe. So thank you for the time, and I look forward to questions.
Good morning, and thank you so much to everyone who organized this and worked on this. And I also want to say that everything I'm talking about today is based on work that I've done with two co-authors, Greer Donnelly and Rachel Rebusche, who are not here, but they'll be speaking to you later today. So I want to start where this morning when Nicole gave us introductory comments, she talked about how Dobbs sowed, very nicely alliterated, confusion, conflict, and chaos. And one of the trickiest questions following what the Supreme Court did is to what extent an anti-abortion state can limit people from getting abortions in other states where the procedure remains legal. Medical care providers may think that if they follow the laws of the state where they are, where abortion is legal, they are free from legal liability regardless of whether they treat an in-state or out-of-state patient. This is sort of consistent with how we think of going about our lives in the United States, where if we travel, we pay attention to the laws where you are when you're traveling. Think of gambling in the United States before it became prolific in a lot of other states. If you went to Las Vegas to gamble or Atlantic City, you didn't worry about what your home state laws were with respect to gambling. This common intuition that we have, though, is not really consistent with how the law actually is. Not necessarily how it's worked, because prosecutors haven't tried this with these other things. But unfortunately, there's not a clear impediment in American law to states reaching across borders to enforce their laws. And there are two possibilities in how states can do this. First, they may try to use existing civil or criminal laws against someone in another state, and there are legal doctrines that would allow them to do so. One is, in the criminal context, the effects doctrine, that if action taken in another state has the effect in a state, that state may have jurisdiction to prosecute that action even though it took place somewhere else. The second is if any element of the crime takes place in the state. So if someone develops the mens rea in one state, even if all the action takes place in another state. Or think in the context of medication abortion, that can take place in many different states, right? Where the pills are given to someone, where the first pill is taken, where the second set of pills are taken, where the contents of the uterus are expelled. That can take place in 4 different states. And so maybe 4 different states have jurisdiction there. Second, legislators can actually try to pass new laws to try and capture abortion-related travel. And we haven't seen those laws passed yet. But we have seen legislators talk about these laws, and I think in the coming years we're going to see this. In response to this concern and this sort of confusion over extraterritorial application of law, 7 states have enacted a new type of law called a shield law. The provisions of these laws vary, but at their core, they seek to protect abortion providers, patients, and helpers in states where abortion remains legal from legal attacks taken by anti-abortion state actors. I want to go over sort of the basic elements of some of these shield laws and then talk about some of the concerns with them and some of the efforts to get them passed. So in the 7 states that have passed these laws, there are, we broke it out, 9 different provisions, and I can't go into them in depth given the time, but I'll just sketch the basic idea. One is protection for non-fugitive extradition. So the Constitution requires that if someone is fleeing from a state, they have to be extradited. There's no discretion for a state. But if someone has never stepped foot in that state, so say a Massachusetts provider who cares for a patient in Texas, Texas tries to prosecute that Massachusetts provider, but all the care took place in Massachusetts, Massachusetts does not have to extradite. They can, and many states have voluntarily said in their statutory law that they will extradite, even if the person never was in the other state. These shield laws have said we will not extradite for lawful reproductive health care in this non-fleeing situation. 2, we will protect interstate witnesses from being subpoenaed, summoned, or deposition requirements from other states. So if another state tries to use its legal process to force someone to be a witness or even a defendant in a case in that state, normally what happens, say if Rhode Island wants to have someone from Massachusetts testify in a Rhode Island court, that person can voluntarily comply, or the Rhode Island lawyer will have to convert the Rhode Island subpoena into a Massachusetts subpoena in a Massachusetts court, and then the Massachusetts court is forcing them to testify. These laws say that these requirements will not, or sorry, these orders will not be converted to a home state order if it has to do with lawful reproductive health care. 3, we will not expend resources to cooperate with investigations across state lines. So our police departments and other investigatory resources will not cooperate across state lines. 4, in context with the first discussion in this panel, we will limit the adverse licensure consequences. So if one state disciplines someone from another state, that for lawful care in that state, they will not recognize that discipline as they otherwise would, and it will not affect their license. 5, also similar with medical malpractice insurance, because if you get sued in one state, that will often up or maybe even force your medical malpractice insurer to drop you, and that cannot happen in these shield laws. 6, prohibiting disclosure of patient information, so that patient information is protected from being obtained by the anti-abortion state. 7, protection from out-of-state judgments. Now, the full faith and credit clause requires recognition of out-of-state judgments, but there are some exceptions, and these laws work within those exceptions. 8, creating a new tort for tortious interference with reproductive health care, so that if an SB 8 lawsuit is filed against a provider, say in Massachusetts, and the Texas courts find that this person is responsible for $10,000 or more, as the SB 8 allows, that when that judgment is being enforced in Massachusetts, that creates a new cause of action that provider can sue, saying you are now interfering with lawful reproductive health care, and I can get as a judgment the amount that you got against me in Texas. It's called a clawback lawsuit, and all of these shield laws have those. And then 9th, and this is probably the most controversial, and so far Massachusetts is the only state which has a provision like this, that allows for caring for patients across state lines via telehealth. So under the Massachusetts Shield Law, a Massachusetts licensed provider who is in Massachusetts can care via telehealth for a patient in another state. This goes against basic health law understanding of telehealth and how it works, which is that the location of the care is where the patient is, not where the provider is. Massachusetts has reversed that for the context of the Shield Law, not generally under Massachusetts law, for the context of the Shield Law. And this would allow, with some caveats, Massachusetts providers to care for patients in other states using telehealth, and that can be for early medication abortion. So far, no Massachusetts provider has taken advantage of this because there are serious logistical challenges, but there are many working on it. 7 states have passed these Shield laws. Connecticut led the way with the first one in May. Since then, California, Delaware, Massachusetts, New Jersey, New York, and Illinois have all passed them, with Vermont, Colorado, Washington, and Maryland considering laws right now. I testified in the Vermont and Washington legislatures earlier this week talking about them. There are also 12 states that have executive orders, as was mentioned earlier, from their governors. The executive orders are more limited because they can only cover things that the executive branch controls, and so that's statewide investigations, extradition, some licensing issues the executive branch can control. Shield laws are an important legal development to help abortion providers, patients, and helpers in this post-Roe environment. However, as much as these laws do, they can never provide complete protection against legal consequences. For one, Shield laws do not protect providers from consequences in the other state. There is nothing Massachusetts can do to stop Texas from going after someone in the Texas courts. Now, it can blunt the effect of that by saying we will not cooperate with your subpoenas, we will not extradite, etc., all the things I listed, but Texas can still go on and do this. So there's still a risk that the anti-abortion states will go forward with their processes, and there's nothing the states that support abortion rights can do. Second, some of these Shield laws are certainly going to be challenged in courts, which might strike them down or interpret them narrowly or differently than how we intended them to be interpreted as we've developed them. We do believe that all of the shield provisions that I talked about are constitutional as a general matter and should be upheld by the courts. However, not every court in this country might agree with that, especially given how abortion rights claims have fared before certain courts in recent years. Third, the nuances of these shield laws vary from state to state, and it's important for anyone thinking of taking advantage of them to look very closely at what they involve to make sure that they're covered. I want to use the remaining 2 minutes to just talk about sort of how this has not been universally applauded even within the movement for abortion rights. This development of shield laws has been very divisive. Greer, Rachel, and I have worked very closely with the Center for Reproductive Rights on these shield laws in almost every one of the states that I mentioned, but not everyone in the movement feels the same. They believe a few different reasons. One, that if you can never reduce all the risk, then you are creating a false sense of security in providers, that the providers will not understand, because they are not the legal, they're not lawyers, they will not fully understand the risks that they have in those other states. Two, it goes against a basic constitutional vision that we generally support, which is that states will respect the actions of other states. This is really essential to many things that are important to everyone in the movement and everyone who cares about social justice. Three, that it goes against some things that should be prioritized right now. Shield laws should not be that priority. And four, it furthers this idea of abortion exceptionalism. In most contexts, abortion exceptionalism has been harmful to reproductive health and justice. Here, we're basically saying you should treat abortion different than you're treating everything else under the law. Despite these challenges, though, we and those who've worked with us and the legislators who have worked on these things believe that this moment needs to be met with these kind of extraordinary actions to deal with the situation that providers need to feel safe treating patients from other states because of the intense amount of travel that is happening around the country. And in the Massachusetts example, which we hope to see replicated in New York and Colorado soon, for patients who can't travel, that given the moment and given the need, these are extraordinary measures to meet these extraordinary times. Thank you.
Thank you. Hello, everyone. Thank you so much for this opportunity. Thanks to Nicole, Aziza, and Linda for including me. I was saying this morning, it feels a bit like a family reunion. It's so nice to see so many of my community in this area dwelled for decades, and it's a thrill to be here. And I have to say, as a dean, as an aside, thank you for the distraction from budget and other administrative niceties that I spend most of my time on. I showed this slide to my students and thought it was so cool to talk about technology and, swiping right and swiping left when you're trying to create families. But I realize now I have to update this with something that says GPT can now achieve reproduction. I'm sure that many of us are considering the AI implications here. This slide is probably very well known to most in the audience, just an epidemiology and a review of just how vital and how much reproductive technologies do dominate family formation in the United States, and it grows every year. So my talk is going to be about the impact of Dobbs on these technologies, which are so much a part of people's lives and the family formation that they desire. So currently, with IVF and therapeutic donor insemination, we have about 3% of the U.S. population born as a result of these interactions, far exceeding the number of families that are formed through neonatal adoption. So it's very relevant to our social structure. And again, it's been much trotted this morning, but just a reminder about how far back our jurisprudence surrounding reproduction and the protections that we've enjoyed for so many decades goes back, of course, to Skinner versus Oklahoma, in which we have this very broad-minded, broad-based statement about procreation of civil rights. right. And then, of course, moving up to Roe and Casey. Again, not to spend too much time on this area, but it's fair to say that whether these, and I'm going to go advance to one other slide and come back to this one, whether these kinds of precedents have even protected the right to assisted reproductive technologies has been much in dispute. In fact, many in the room have written about this, either arguing in favor of or warning that the thin reed of Roe and Casey cannot support decision-making or restrictions on the right to access assisted reproductive technologies. And one of the frailties that was pointed out prior to Dobbs about the application of Roe and Casey to ART was the bodily integrity portion of the jurisprudence. That is, to the extent that, particularly in Roe, where there's discussion about the decision-making that protects one's bodily integrity, that this could never be availed by those who reproduce through IVF, because, of course, the procreation that's really relevant in that clinical scenario takes place in a laboratory setting, that there's no interaction with the patient and the embryo until a much later point. And so that frailty really kept many from applying the jurisprudence surrounding abortion to IVF. And I think it's ironic and interesting, and I talk about this in the paper more than I will today, that the bodily integrity aspect of IVF might be exactly what saves it from being captured by the restrictive regulations that we're now seeing surrounding abortion. So I'll talk a bit about that. Just going back to Dobbs again, just from my portion, my small world, to talk about that, what I'll say is that, of course, the justices never discuss IVF or assisted conception or any other form of family formation in the opinion. So there's no expression at all about whether the language in Dobbs would apply to IVF or any of the other technologies that are either used or emerging in the field. But what we do know and what's been discussed is the language and the emphasis on embryo protection, elevating the potential life and unborn human being scenario over any concerns about the patient's, their health or their social family desires. So that's where we can start then our analysis of the impact of Dobbs on IVF. And in the paper, I talk about three vulnerable aspects of the clinical practice that are very much of concern to reproductive endocrinologists across the country. And I'm really going to focus on one of those today, but I'll mention all three. So IVF almost universally in every cycle that is successful, that is, that produces embryos, involves embryo discard. It's very rare for an IVF cycle of the 200,000 that are undergone every year in the United States to not involve some form of embryo discard, either initially at the time a fresh cycle is contemplated or later on when cryopreserved embryos are thawed or might be discarded for a variety of reasons. And so it's that core and really important part of IVF that's really under fire, potentially under fire, through the restrictive abortion regulations. And again, it's important to know that these techniques of discard and cryopreservation are really essential to the success of IVF as a clinical practice and to the desires of patients for their family formation. A second feature of IVF that's increasingly utilized is pre-implantation genetic testing. It occurs in about 60% of all cycles that are performed in the United States today. And it's done either through biopsy of the embryo, or increasingly there's some research on actually just looking at the culture medium to detect the genetic makeup of the embryo. And the PGT is vulnerable in ways that we might not expect, because you'd think, well, testing the embryos, it doesn't harm them or kill them. In fact, many studies have shown it to be safe, and the embryos go on to develop normally. The problem is that the intent behind PGT is really deselection. It's to identify anomalies in the embryos for purposes of deselection. To date, we have no clinical modalities that can interact with an embryo that can cure or fix genetic anomalies. And as you might know, on a secondary matter, germline gene editing in the US is stalled at the very best and prohibited And so we're not moving forward with any cures that would interact positively with PGT, meaning that its only purpose is to deselect an embryo. And then finally, selective reduction of multiple pregnancy. About 20% of IVF pregnancies in the US today, a little bit less, are multiples, twins, or sometimes higher order. And there are techniques that can reduce the number of fetuses in the womb, roughly the 9th through 11th week of pregnancy. And while some would say that's an abortion because you are killing the fetus, the fact is you're not terminating the pregnancy. So depending on what the language is on restrictions, certainly selective reduction could come under attack. So do abortion restrictions, even the most grand or broad or all of them, do they apply to IVF? The vast majority of abortion statutes in the country, the trigger laws, as well as existing laws that are utilized today, define abortion in terms of pregnancy termination. So the situs matters in that case. Where life begins can actually be the definitive distinguishing feature between abortion and IVF, because there is no pregnancy, at least not in the clinical sense that we're used to hearing. And so for that reason, we could safely say that the restrictive abortion laws do not apply to IVF because they only look to pregnancy termination. And so they wouldn't be within the reach. And again, I just have some examples. Ohio, you can see, and this is very classic, abortion is the purposeful termination of a human pregnancy. Even though many of the statutes define the unborn child from conception onward, they link it and they tether it to the pregnancy. But there are some exceptions, and I know we have a faculty member from Utah might speak to us about the Utah law, which is kind of unique in really not tethering the intentional killing of the live-born human child through to a pregnancy scenario. So there is some concern, although for the most part, the language seems straightforward. Well, given that, what guardrails protect against sweeping IVF into abortion restrictions? Well, I think just from a clinical point of view, it would be highly problematic and highly disruptive to this field in which so many families experience joy in childbirth over many years. First of all, the notion that you would not be able to discard any embryos in a fresh cycle, that is where you create the embryos, you grow them to about 5 days, and then you transfer them into the uterus for hopefully implantation and pregnancy. In a restrictive jurisdiction in which you could not discard any human being, including an embryo, you would be forcing the transfer of all embryos that are formed in a cycle. And the problem with that is that IVF remains more of an art than a science. Ovulation induction is highly imprecise, and we still cannot figure out how to get 1 or 2 eggs from a particular cycle. Now, we could tell the surgeons to just extract 1 or 2 eggs from the ovary after the ovulation induction period, but it's very wasteful. It's also very difficult for women who undergo IVF because there's a number of morbidities and mortalities actually associated with it. So to force women to undergo ovulation induction for every cycle is highly inefficient, and medically it's very perverse, and I can't see that moving forward. The field is moving to what they call freeze-all cycles. So instead of any fresh cycles, all of the embryos are frozen. Now, what that means is we have to be concerned about freezing being considered some kind of a tort, like assault and battery, because we wouldn't freeze a person. And so for freezing an embryo who's regarded as a person, then it could be intentional infliction or some other considerable crime or tort. The other aspect of guardrails that are up is the whole fetal personhood movement. I know others in the audience have talked about that, but the concern is that if the fetal personhood movement gains strength and continues to dominate the legislature and so on, then the idea is that the rights-bearing embryo from the moment of conception forward would not be able to be discarded or frozen and so on. Just all I'll say about that is I have more of a political response to that than a legal or a medical one, which is it seems that the uptake of IVF in political circles, infertility knows no political affiliation. And we know that people will turn to IVF despite or because of either their political or their religious affiliations. In fact, recently, former Vice President Pence revealed in an interview that he and his wife Karen had turned to IVF for their children. And you might know that he's one of the fiercest so-called pro-life advocates, but he talked to the reporter about IVF exceptionalism, and we need to protect these fertility treatments because they help me and my family. Sorry, I'm a little cynical about that, but in the end, it actually might be the path forward. In the paper, I described some frameworks for evaluating abortion laws in the context of IVF. I'm just going to mention one because it was so nicely described earlier in our panel. It's this bodily integrity approach. One of the surprising aspects to me about Dobbs is in the listing of all of the cases in which the liberty interest is at stake. Oh, I'll finish up. I understand. It's me or lunch, and I understand the choice. But you know, all of the decisions that are listed from Griswold on, no one talked about Cruzan. And you might remember that Cruzan does depend on the liberty interest. It elevates the liberty interest for competent adults to make decisions about and to avoid unwanted medical treatment. And so it might be that an argument could be made that forced transfer of embryos and even forced pregnancy is in fact a violation of this liberty interest. Call your attention to a great Kentucky case, which is challenging our abortion laws on religious freedom grounds, something to watch. And just finally, I want to mention the distributive justice offense that I think is really dominating this discussion. It's been mentioned by my co-panelists. If you think about the people who use IVF and the people who use abortion, they're very different from a socioeconomic and racial perspective. And to me, the argument that's been given in my field by some of our physician friends is that IVF should enjoy some exceptionalism from the abortion restrictions. I think that's highly problematic to create these two camps of very different types of patients. Reproductive justice means that any way in which we control our reproductive health should be regarded in equal measure. So with that, we're working on it. I'll put AI in that next time, creating babies. And thank you so much for the opportunity.
Thank you. While I begin to check for questions from our virtual audience, I'd love to see if any of our panelists have questions or comments for one another. To kick us off for a few minutes of Q&A, David.
Yeah, just quickly, Judy, I know because Georgia's abortion law allows abortion up to 6 weeks, but the same law also says that from the moment of fertilization, in all other aspects of Georgia law, this is a person. So do you know if the things you were talking about at the very end, has any of that been impacted in Georgia because of that unique part of the Georgia law?
Yeah, I mean, Georgia, as you might know, is the only state, I believe, and please correct me if this isn't right, to have actually enacted a fetal personhood statute. And so that is of interest to the field. And, talking to REs in Atlanta and so on, again, there might be those closer to it. I think that what's happened is in these states, you have some of the lawmakers and other sort of political types making public statements that we don't mean it to apply to IVF. And they've been quoted in newspapers. They've said it on the floor of the legislature. So at this point, we're kind of depending on this dicta of sorts to permit the proceedings to go forward. And again, I'd be very interested to see if a state marshal shows up.
So we have to exit the room by 2 o'clock. We have to get to these panelists because on our very long roundtable, we have a star-studded group of people for you to hear from. And I'm just going to introduce them very quickly. And this is meant to be a roundtable and more conversational. So I'm going to start by posing a few questions, and actually I'm going to let folks first go down the line and introduce themselves. So I'm just going to start with my introductions as they are on the program with Judy Norsegian, who's a founder of the Boston Women's Health Collective, active in Our Bodies Ourselves Today, the only women's health advocate that I had to wait an hour for after a panel while she signs autographs. Next to her, we have a board member of Our Bodies Ourselves Today, Diana Namambuje Aboya, who is a practitioner at the Lowell Community Health Center. She's an activist not only in the United States, but in Uganda. And we're so happy to have you here to talk about your experiences around the world, and especially in immigrant communities and in communities here in Massachusetts. We have Kimberly Mutcherson, who is a leading voice in reproductive justice. She's also just happens to be the dean of a law school, Rutgers. So thank you for making the time for this. We have Nashira Burrell, who's one of the leaders in the movement for neighborhood growth centers and racial justice and birthing. And you know, one of the exciting things about this panel is it's us really signaling to the world that it's not only abortion that matters in the fight for reproductive justice. It's pregnancy, it's safe pregnancy, it's inclusion, it's racial justice, it's everything. We have Maya Mannion, who is a leading voice in the intersection of sociology and law and talking to providers and thinking through questions of law and medicine. Elizabeth Sepper, Liz, who is who's leading the conversation on the intersections between religion and law and what's going on in the context of religious exception, Catholic hospitals, and really helping us all understand how those various complicated worlds interface with one another. And finally, Renee Landers, who's with Massachusetts Planned Parenthood, but also a leader in the regulation of law and of medicine and teaches at Suffolk Law School. Thank you all so much for being here. Our plan is that we initially go down our roundtable and have everyone just say in a few sentences the issue that they're thinking about most. And I'm going to turn to the lawyers to ask, from your specific perspective, what are the most pressing legal issues that we face? Renee, would you start by just telling us, from your perspective, what are the things we should be paying attention to today?
Sure, thank you. It's really a pleasure to be here, and it's wonderful that you have such a large audience for this conversation today, which I think is very important. So the issue that I've been thinking a lot about is what the impact of a lot of restrictions on reproductive health care, defined broadly, may have on the population of the healthcare workforce. Will they choose not to study or work in states which have restrictive abortion laws? And the reason that not only will that have a deleterious impact on reproductive health care, but it will also have a deleterious impact on all kinds of healthcare that affect the quality of life for people. And so I do think that is a real concern. And part of my research agenda is to think about to sort of watch what happens with applications to medical schools, where people decide to go, what residency programs experience, whether they experience any fall off in applications, depending on what the legal situation is in their state, and and sort of what happens to the population of care providers, OBGYNs, and others in those states. So I think that is a real and significant concern. We'll get to the optimistic points later.
So I'm thinking primarily about the ways in which the First Amendment has a role to play with regard to abortion in 2023, which is to say we're already seeing quite a bit of chilling of speech in a number of ways. Chilling of speech both in the form of providers not giving patients information that they actually legally are allowed to do in states like mine, but nonetheless they're reading the law to prohibit or to chill speech they would otherwise engage in. Abortion funds in the state of Texas are not operational. They have not been operational since the Dobbs decision basically was handed down, and significant chilling there. Speech, right? So chilling donations along this ground. I'm also following closely. There are a number of affirmative lawsuits that have been filed, raising both establishment and free speech claims against a variety of abortion restrictions, with some success thus far in state courts, primarily around the country. I'm happy to talk more about those, perhaps a positive note.
So I think for me, the thing that I am most concerned with is, frankly, how emboldened state legislators feel right now, right? I mean, they basically had this huge victory from Dobbs, and we know already, as somebody said earlier, that the lawmaking that is taking place there often has absolutely nothing to do with actual medicine or science, and there's no sort of sense of backstop anymore. So what I'm really concerned about is what states are going to do with their newfound power to protect potential life. So I'm thinking about cases like some of the forced C-section cases where courts would actually say, well, Roe and Casey mean that you can't force this. I'm thinking about what's going to happen with assisted reproduction, as Judy was talking about. If frozen embryos are children and people aren't going to use them, then why wouldn't we just put them up for adoption and we could just give them out to other people who want to use them? So I have some serious concerns about what's going to play out there. And then finally, a lot of concern about criminalization. And we know exactly who gets targeted when states choose to criminalize behavior during pregnancy. And so again, that sort of sense of expansion of their right to protect fetal life and potential life is going to have really negative impact on poor women, women of color, women who are undocumented, right? The whole list that you can imagine.
For me as a practitioner, what I'm mainly concerned about is access to reproductive health, be it contraception, be it abortion, and how it's actually widening the already existing gaps in maternal health outcomes between people of color and their white counterparts. And how it looks like on my end is in Massachusetts, not quite a very big issue, but we still have these problems here. But in other states where they already pre-existing problems, like no insurance, like no money to pay for co-pays for contraception, things like access to basic healthcare and prenatal care. And if we have such a decision in place, then the gaps will be widening because they have to figure out how to pay for all these things. If they happen to be in a state where abortion is not legal, then they'll have to figure out, how do I travel to go access abortion elsewhere? Not so much a problem for people who have finances and people who can pay and travel and receive all these things, but so much for those individuals who still struggle in terms of finances, in terms of appropriate care, in terms of racism within the healthcare systems, we keep saying. And then also the immigrant communities, particularly the community I is of immigrants. And I'm thinking about, sometimes I routinely get patients who come in from the border and they're about 8 months pregnant. And sometimes they've gotten pregnant while they're at the border. And who knows what care they've had. They're always at the mercy of the government. And so I worry about these populations in the sense of how are they getting access to these resources in detention where they are, because they tend to be set out to come to us in the communities when they're far along in their pregnancies. And the question still lingers, did they really want to be pregnant while in detention? Did they have access to contraception? In that's something I worry about.
Well, I just have to say that I am always learning from Diana on the board of Our Bodies, Ourselves, and her work in Uganda has been totally inspirational to me. She produced the Ugandan edition of Our Bodies, Ourselves and thinks about things outside the box in ways that we have to now around the post-Dobbs decision world that we live in. And I'm also trying to be optimistic and find more and more reasons to be feeling that way, partly because I've seen firsthand how that decision has galvanized groups of people who have been largely inactive in setting public policy, who's running for office, and with a lot of other people. I've been concerned about the future of democracy and the lack of public participation. And I think I have seen more public interest and participation since this decision. And it's been affirmed by things that others have said to me. A friend was canvassing in New Hampshire last year, and 3 Republican men who normally voted Republican weren't in that midterm election, all because of Dobbs. And they referred to their wives, their daughters, the reality of what it meant. And it took me back to years ago when Scott Brown was running for the Senate. Some of you who are local remember that. My own niece, and mind you, she knows what I do. She's graduating, and I'll tell you, from Reagan High School, not too far north from here. And I was asking her about how excited she must be about being able to register to vote. She's just turned 18. And I was met with a blank stare. Not only had she not registered, none of her friends had registered. And all I needed to do was tell her something about Scott Brown's position on contraception, forget about abortion. And the next thing I knew, the next time I met with her, she and her friends had all organized, they'd all registered, and they were going to vote. because this mattered to them and something had been brought to their attention. And I think right now we have this amazing opportunity to lift up all the ways in which this decision has been and would be harmful, and at the same time do the things we can do and get done because of it. And so I'm more optimistic than I was in the very beginning, and my 1970 classmates who met at a 50+2 reunion this past June all galvanized around this issue in various ways from whatever states they live in, and it made me realize that it isn't even tied to your age. It's just a reality that this is something most people care about in one way or the other, and they'll tie it to other issues. So I'm optimistic, unlike I was before.
Good afternoon. It's really nice to be here. I'm thinking a lot about the regulatory and philanthropic context here in Massachusetts and across the country around the opening and sustainability of community birth centers. And in particular, that the presence of a community birth center doesn't automatically ensure access to abortion or full spectrum reproductive health care. And so, and therefore doesn't advance reproductive justice inherently. So the work that I'm doing here in Boston, which we can talk more about, and nationally, is really getting at the root of inequity in how birth centers are started, how they're, who gets access to care, and how we really, from real estate through, you know, insurance reimbursement through patient care, are thinking about a more sustainable model, which really requires a radical reimagination and a reclaiming of midwifery and reproductive justice.
Thank you. Thank you, everyone, for being here. So I'm thinking about the ripple effects of the Dobbs decision on healthcare beyond wanted abortion care, and cataloging the evidence we already have and the evidence we need to gather going forward to help the public understand the full breadth of healthcare impacts of the Dobbs decision. So we heard a lot about that this morning from these wonderful panelists on all the impacts of Dobbs on pregnancy-related care, on birthing patients, on assisted reproduction. And I'm looking even broader than that. So for example, we have some anecdotal evidence that more people are asking to be sterilized because they are afraid they will not otherwise be able to control their fertility if they don't have access to contraception or abortion. So are we moving into a new form of coerced sterilization? We heard about the history of the eugenics movement this morning, and you know, we keep seeing new eras of neo-eugenics. And so how does Dobbs relate to, how do abortion bans relate to eugenics in that way? There's been lots of reports of impacts on non-pregnancy related care in rheumatology and oncology, pregnant people with cancer. So really trying to set forth how abortion is deeply interrelated much more broadly with healthcare. We hear advocates and politicians saying abortion is healthcare, but in the law, abortion has been siloed and segregated from healthcare, and even in medicine, abortion has been really segregated from mainstream medicine. And so perhaps if we can reframe the public's understanding of abortion as really deeply intertwined with a broad range of healthcare and with less stigmatized forms of healthcare, if we could say, hey, these abortion bans affect you, even if you think you don't need or you don't know anyone who needs an abortion, these bans can affect you as well. And so especially in a post-COVID world, linking this up with health justice and framing abortion rights and reproductive rights as about health justice as well. Thank you. Okay, so I'm going to pose my first question to the lawyers on our panel. So Renee, Liz, Kim, and Maya. And, you know, you've already kind of given us a little teaser about some of what you work on, but, you know, in this moment where there's so many legal transformations occurring at once, you know, we've already heard many presentations today on various parts of the law. I was wondering if you could just tell us a little bit more about what you feel is one of the most, you know, the more pressing areas that we should be paying attention to, whether it's from your perspective as a scholar or activism you're involved in, personal experience, whatever it is. Okay.
So one of the things I wish I said as the conversation went on at the beginning was that in addition to how reproductive health care is intertwined with all other kinds of health care, it's also intertwined with a lot of other societal issues. The you know, sort of lack of support in our country for families, the lack of financial resources that low income populations experience. And so one of my concern is this, whole conversation about debt limit, cutting back on domestic spending, and the impact that will have on programs, healthcare programs and other kinds of, policies like, support for family leave policies and so forth. I'm also concerned that it will, that it will affect it will affect healthcare programs. The Medicaid issues, Medicare issues, all of these things that are essential for families to have kind of a sustainable life. And so one sort of bright spot in this whole picture is that there have been a lot of pilot projects going on around the country on income support, guaranteed income. There are two really prominent ones in the local area here in Cambridge, Massachusetts, and Chelsea, Massachusetts. And the objection to them has always been when people will wait for money, and we need to micromanage how they spend the money. And the fact of the matter, there's been very careful tracking in these pilot projects, and people do things like use them for co-pays for going to the doctor, for medical appointments, additional food, all kinds of activities for their children. So people are using the money, and it gives them a little bit of breathing room in their lives so that they can actually have more fulfilling opportunities and engagements with society. So I think that I would like to see more of a recognition of that kind of level of community support for individual families in the country, and I'm working on some issues related to that.
So I think another big change that is running into the Dobbs opinion in the Supreme Court's doctrine is the turbocharging of the free exercise clause. We saw that it's been less than a decade, basically, but the Supreme Court has really turbocharged. The free exercise clause allowed it to eat up a lot of social programs. Think of the contraceptive mandate. Think of prohibitions on state funding to religious education. All through the free exercise clause, we saw pandemic measures taken down with new interpretations of what free exercise requires. Now, in this whole campaign, I think that the Supreme Court, and this is important to rule of law, would have said it would be even-handed, right? That's what's good for the goose is good for the gander. So what the court was counting on is there was no gander. Progressive religious people have been sitting on their hands. They have been afraid to make religious argumentation, partly out of concerns that lawmaking needs public reason. And I think most religious progressives are committed to that. If you have religious values and public values, you can make arguments in both registers. Now we are seeing some litigation. We should have seen it earlier. We're seeing it, but the real issue of concern to me is the pushback. So we're starting to see the Beckett Fund is basically arguing that Jews are not sincere, that you cannot sincerely believe that a human life comes into existence at birth. Is deeply offensive, but really dangerous, I think, for religious liberty. So lots of this is ongoing. There's also big picture questions, right? We have state establishment clauses that are more protective than the federal establishment clause, which the Supreme Court has essentially eviscerated at this point. And there's questions, right? If you have lawmakers as a group saying what we're doing here is promoting Christianity, doing what God intended, saying that conception is the moment in which human life becomes sacrosanct, that seems like a problem from the perspective of the establishment clause given religious pluralism in states. So I'll stop there.
Yeah, so I'm thinking about the last slide. I saw Judy come in. I'm thinking about the last slide that Judy put up about distributive justice. And, one of the things that has been very powerful in the world of abortion when it comes into play has been being able to create coalition and being able to create allies, right? So when we had that sort of rash of attempts to create these personhood bills, it was the assisted reproduction people and the abortion people coming together that really helped to crash a lot of those efforts. And so what I really don't want to see, this sounds on some level really terrible to say, What I really don't want to see is people who have power carving themselves out, right? Carving themselves out of the bad outcomes that flow from Dobbs, right? So say, for instance, IVF is not a part of, it just doesn't fit into this at all, so we shouldn't even talk about it. Because that sort of ruins the coalition. And unfortunately, I feel like we need that coalition. We need the power, that organizations like Resolve, which is fighting for infertile people, we need that kind of power. And we need, frankly, the reproductive endocrinologists and these other folks to be in this fight. And they don't have to be in this fight if they get carved out. So I'm hoping they get dragged down with some of this stuff. So we might actually be able to win some of this.
So I teach constitutional law. We're all still just have our heads in a spin over Dobbs, but this term we have cases on affirmative action and voting rights, and both are going to be gutted. In Dobbs, the court said, let's return this to the people and let them vote on it. So of course, the next move is to attack the ability to access the ballot. The midterms gave us a lot of hope, right? That we saw how those ballot initiatives went down. So the next move is, how are we not going to have ballot initiatives anymore at the state level? So because abortion is no longer a constitutional right, it is now in the hands of the people. I am really concerned about all the different moves the court is making on the right to vote. So there's an attack on voting rights. That's up this term, a further attack on voting rights. We already had a case, Shelby Kellner versus Holder, which partially gutted the Voting Rights Act. Now it's going to be fully gutted. We have a crazy case on the independent state legislature theory, which if you listen to the podcast Strict Scrutiny, they call fan fiction, which it basically is. That could have huge impacts on our electoral process. The court's already said it's not going to hear any cases on partisan gerrymandering. There's so many, and then of course we have First Amendment law that says money is speech. I mean, there's so many different pieces of the constitutional puzzle that are converging and restricting our right to vote. And that of course now is just fundamentally tied up with whether or not people around the country are going to have access to comprehensive reproductive health care. So I'm very, very concerned about that.
Now that we're all feeling super anxious, turn to the practitioners, and then we'll come back to maybe a little bit about what we can be optimistic about. At least we had David this morning talking about Sheila's, yeah.
So, I think this has changed how we practice medicine. I would speak that I'm so lucky to be practicing in Massachusetts for sure. But also I have a limitation because I practice in a health center that is federally funded. And in this health center, I still cannot provide abortion care. My colleague, I do have a few colleagues who provide abortion care, BMC and second trimester abortions as well. And they're really swamped because we're having a lot of people traveling in who have access to these resources that we are providing in Massachusetts. So it's sort of overwhelming, the system and the appointments and the waiting and teasing out who goes first. For my colleagues in other states, I think about being pressured to know that this individual right in my exam room needs an abortion or wants an abortion or her medical situation requires one, but I have to consult a lawyer before performing it. That's insane because in my training, if someone needs something medically, and it's by the guidelines, I want to give it. But if I have to think about, for instance, in Wisconsin, where someone could actually do 6 years in prison if a prosecutor decides that the abortion wasn't warranted in his situation, then I worry for my colleagues there. Think about things like oncology in Texas, where they are waiting a few days to treat a patient because with the hope of maybe this individual will worsen and need an abortion because the treatments they're going to give are in itself going to cause harm to the fetus. But they cannot go ahead and do an abortion to start treatment because it changes the ball game due to the laws, in this place. And being in an emergency situation where someone has to first call the lawyer and review whether, what situations are we looking at? Should I go ahead and have an abortion? It's limiting how these practitioners are doing medicine in those other states. I think the other thing that I'm concerned about is the issue of language, and I'm going to speak to this as a, a person who speaks several languages, but also came in and navigated this health system as an immigrant woman. The truth is, these things that we're discussing here do not make sense to my patient population. I remember having a couple in my exam room a few weeks ago, and the gentleman said, well, abortion is illegal, right? And it doesn't make sense whether they're in Massachusetts, wherever they are. To them, someone said on the news that abortion is illegal. And so part of the focus is thinking about how are we going to educate even the people who have limited literacy to understand what they're talking about, because all these things actually impact their health outcomes. And so some of the things, those are some of the things that, I feel like partnering to the situation that really affect how we practice in Massachusetts and how our other colleagues outside the country are having to practice, unfortunately.
So it's really hard to kind of look back, and 50+ years ago, I think there was a sense we were going to change things much quicker and change things maybe a little bit, not much, but, and here we are now, and I don't think anyone would have predicted this, but the thing that was true then has always been true, is that it ends up being about who has political power. And it's why we always said in feminist circles, the personal is political, because you need the political power in your relationships, in your community, in the halls of Congress, in your legislatures. And unfortunately, more and more getting that political power means having money. And that poses a huge obstacle, because there's an enormous gap here between, the most wealthy and the least wealthy, and the ones who are most wealthy are using that money in ways that you who are lawyers are probably watching much more closely than the rest of us. But it's palpable. And the only thing we have to go against that is some sort of a grassroots mass movement. And it does require touching base with everyone in our circles any way we can. If we, have a Twitter feed, if we do social media, use it. If we just go to a lot of social events, use it. And I'm thinking that now is the moment for us to really, particularly around this issue, look at the really good groups out there and lift their voices. They're doing the homework. They're giving us the talking points. You've got If, When, How chapters here and elsewhere, which are great organizations. Obviously, you've seen a lot about medication abortion and Plan C in particular. Well, several days ago at Sundance, Plan C, which is the name of the new documentary, got a huge response. And I think it's going to hit theaters, and I think it's going to be something you can get friends to see, even if they don't care much about abortion. There's a story in here that goes deeper than abortion. It's about community empowerment, and it's about speaking up. It's about the missing voices. And it's a little bit like a drama as this documentary unfolds. And I think you'll find it fascinating. I mean, it includes Francine Coito and her colleagues running around these corridors in the universities in Texas, trying to find the best bathrooms to put on all these sort of stickers about where you can get medication abortion, who you write to. And as some of you know, there's a group called 8 Access, founded by Rebecca Gompertz, the famous woman on waves person who's putting her ship outside of, in the sea, near countries where abortion was illegal, and creating a lot of media attention. But 8 Access is now a major way that women in many places can get medication abortion through the mail. And this is crucial. The women in Mexico who are coming over the border to help their sisters in Texas. This is amazing to watch, and they've been fighting their own battle there, legalizing abortion and doing what they need to do. But I think people helping people is going to be the message we have to constantly share with others, whether it's at the personal level. Folks in Southern Illinois are starting this center, which isn't just an abortion center for largely women in other Midwest states and in Southern states and people who need abortions. But it's also like a call center where if you need childcare, if you need transportation, if you need funding, if you need lodging, they're going to tend to all of your needs in your search for a needed abortion. And those are the kinds of creative responses that will galvanize people who may not want the political sort of battle, but they'll happily help individuals. So
when you talk to people, figure out where they're willing to help, how they're willing to help. I have friends who won't sign a petition. It's a rule. Okay, you don't have to ever sign a petition. You got to do something because I know what they believe in. So I find the something that they can do. And I think that we've got tremendous opportunities now because so many people are galvanized around this issue. And I'm hoping like we can fight this effort to stop, ballots, on state referendum, because it was fascinating to watch Kentucky and Tennessee and all these states, one by one, do what I might not have predicted, but it shows that if people are given awareness of what the issues are, then they have an opportunity to lift their voices. They will, and we know we're in the majority on this and other issues. So that's just my initial response to all of this. And I want to say, as individuals and as groups, you can all go to the Sister Song website. And right now they have a new statement. They've been one of the leaders in promoting reproductive justice, birth centers, midwives, abortion access, access to contraception, safe streets, communities free from violence. Well, Sister Song has a new statement that groups and individuals can sign on to. It's their 2023 statement. And I urge all of you to lift that up and share that as well. There are Women's Reproductive Rights Assistance Project, RAP, and groups like that. They're lesser well known than the national groups you heard about this morning, but they're doing critically important work. And we're at Our Bodies Ourselves, we're listing a lot of these sites, and we're really encouraging people to find a way to get active. There's always something you can do, even if you only have 15 minutes in a week.
I'm thinking about the ways that the Dobbs decision has changed the landscape of my work. And I think in some ways it's that I'm here, right? That I'm working to open a community birth center, and that in this moment, there is an increased focus on reproductive health and reproductive justice, that the pandemic has increased demand and reduced access for out-of-hospital birth and community midwifery. So we're kind of in this moment that early in April of 2020, Arundhati Roy, an Indian author and activist, wrote The Pandemic as a Portal, right? And so I really think that we're in this moment where there's this confluence of crises, and what it has done for us, including, hyper locally, the closing of another birth center here in Eastern Massachusetts. It's was run by a hospital, and the Remain closure of the only other one in Eastern Massachusetts. And I think that there's this confluence of all of these crises that are actually requiring all of us to examine more deeply. Folks like Judy and Dr. Joanna Rory and others have been trying to open a birth center here in Boston for how many years, Judy?
More than 40.
40.
So how strong the establishment.
Yeah, so that almost predates me. I'm 43, but I just but now there's this moment that we are accelerating. We're closing on property in Roxbury next week. We have raised we are in a capital campaign, and just to kind of put case in point that this was pre-Dobbs, but just about the kind of impact when there's a crisis and how energy follows, attention follows our energy, right? And so I was working full-time in public health, supporting governmental health departments to advance equity at the start of the pandemic. And I remember texting my board saying, I'm not going to be able to work on the birth center in a volunteer capacity for a while. I have a 2-year-old at home and a first grader at home, and we were all in this moment. And 6 months later, it ended up being the year I worked the most on the birth center, because again, there was this increased demand and attention, and that has just kind of continued to accelerate. And before the end of that year, I left my job to devote more time to work on the birth center. So I think in a lot of ways, the Dobbs decision has, heightened people's awareness to issues around reproductive justice and particularly inequity. And so we are here going we've always been ready to meet this need in our community. And now philanthropy is listening, policy is listening, power, people who hold power are listening in different ways. So it's about time.
Thank you. Thank you. That was very powerful. I'll turn it back over to the lawyers to maybe
say a few things about where you see some optimism, or, you know, or how we might feel a little optimistic about legal transformations. I know Post-Dobbs, everyone and the reproductive justice movement sort of sunk into a hole for a minute, and, you know, help us get out.
You always make Renee start.
Okay. Yeah.
Stay small, stay small. Should start with Maya. You know, I think the thing that, first of all, optimism is just really not part of me. It's very hard for me to practice. But one thing that I am optimistic about is the opportunities that this creates for state constitutions and state law. And state constitutions have been largely ignored by a lot of people for a very long time. And some of them are a thing of beauty, right? I mean, we never got federal ERA. We've got states that have ERAs in their state constitutions. We have states that explicitly protect privacy in their state constitutions. So there's definitely opportunity there. And I'm looking forward to seeing how people are able to exploit those opportunities to create not just a better world in terms of abortion access, but a better world in terms of reproductive justice in general.
I am also Miss Mary Sunshine. As people often say after talking to me, I was feeling bad and now I feel much worse. Okay, so maybe this will all have this right. I think it's good that blue state actors are waking up. There's a lot of restrictions on reproductive health care in blue states that people have been fine with the status quo. I think it's good that men are waking up to some degree and showing up much more than they were before. I think that's a similar kind of phenomenon. I'm in Texas. I don't have such confidence in state law and state constitution. You know, I think there are efforts even in states like Texas to begin to expand some social supports and healthcare supports we didn't have a lot of efforts in that direction before, but it's not going to be comprehensive, right? There's not enough, right? We didn't expand Medicaid in Texas, right? People become pregnant, even with wanted pregnancies, much less healthy than they otherwise would have been. I think some of these free exercise suits in particular are going to succeed in the near term, but I think others will fail, and I think we're looking at a Supreme Court deciding that it doesn't need to be even-handed eventually. But that's going to put more pressure on the court, and I do think that we need to think quite structurally. I also want to add, I mean, another thing that blue states really should be doing, and some states, Michigan, for instance, is looking at, is doing away with right to work. Massachusetts may be one of the few states that is not right to work, but virtually all states are right to work. Labor union participation is affiliated both with voter turnout and with the adoption, for instance, of good social supports and support for reproductive justice. We need union in the fight. We can't have it with right to work laws. And people hate right to work laws. I lived in Missouri, which did not have a right to work statute, went up in August for popular referendum. We rejected it 2-1 in an August voting cycle. So it can be done, but it needs to be done while there's the right political participation.
Oh, Liz is looking at me, so I guess. So I just want to say that I think lawyers are paid to think of the worst case scenario. So it's not surprising that we would have, you know, we think of all the of what could go wrong here, issues. But I think that, well, so I'm going to say a few things about, you know, what I think are some of the risks here, but I think that that turns into an opportunity for us. So I think in the Dobbs decision, you know, first of all, we have Justice Thomas's concurrence where he, you know, sends out the message, please come with these cases challenging these other rights that have been created under the substantive due process doctrine. And then there's that famous footnote, I think it's 48, 41, the one where they list all the cases in which the Supreme Court has overturned a longstanding precedent, right? I think that's the shopping list for other rights that they are signaling are going to be at risk. I don't believe what they say, oh, Brown, the greatest moment of the Supreme Court. No, they don't believe that. And so I think that because now they're going to reach too far, and that is going to build a lot of allies for this reproductive rights coalition and the health equity coalition. And so I think that by overreaching, already there has been this backlash as we have been discussing, and I think there will be more. Another positive thing I think is that, I know this is going to be really super nerdy, is the Dormant Commerce Clause. No one ever thinks about it. My students are like, why are you teaching this? This is so hard. I'm terrible. Someone actually might pay you to litigate this case. So, but the Dormant Commerce Clause, the court has been very unfriendly to states' efforts to freeze other people out. And so they're going to have to work really hard to explain why medication abortion is different. All these other things are different from tobacco, alcohol, all these other things where they've not allowed states to freeze people out, other states out, others. And so I think that that there are some arguments that can be made here that I think will be really useful going forward. So, I will, a little bit of doom and gloom, but I think that the overreach will build allies for our efforts.
I also see hope, as you guys mentioned, what's happening in the blue states, and David talked about the shield laws. I think another thing we really need to work on in blue states is getting rid of mandated parental involvement with adolescent abortion care. We haven't talked about youth yet, I don't think, and this is having an absolutely horrendous impact on young people who need access to abortion care. And we just had a decision in Texas, right, where that crazy judge said that contraception is not something that minors can access on Title X clinics. So what's happening to youth access is something that blue states really need to work on too, because the majority of states, including states that are otherwise pro-choice, often still have some sort of mandated parental involvement law. Did Massachusetts?
Yes, so I was just going to say that what happened here was that we tried to drop the age to the proposal to 16. And Governor Baker vetoed the law because he thought that was too low. Well, it's 16 now, and we were going to drop it lower, and the compromise was 16, and he vetoed the law at 16, and the legislature happily overrode the veto. But I think that even in with people who are generally viewed as being pro-choice or in favor of reproductive freedom, they have their limits. And he also did not like the elimination of the viability standard for late-term abortions. So there's work to do there, but he's not the governor anymore, and and so there may be a chance to revisit those issues. And then the other thing about youth is education, is reproductive healthcare education, sex education in schools. Planned Parenthood has a really great educational program for health, but Massachusetts has failed repeatedly to pass the Healthy Youth Act, which would require sex education, reproductive healthcare education in public schools. So, sorry, I left on to you.
Yeah, so I'll turn to the three of you now, because our practitioners on this panel have basically dedicated their life to addressing the inequalities we see. You're opening the clinic, you're opening the birth center in that was a big mistake in Roxbury, and Diana, you spoke about immigrant workers. Judy, you've dedicated your life to getting information out into the world. I wanted you to talk a little bit more about the inequalities you're observing, the way the movements you're involved in are changing, the problems you're trying to address.
So I personally, and I think I'm looking at this in, with my positionality being who I am and where I practice, which is in a center where I see only refugees, asylees, immigrants, people of color. I think we really struggle with cultural safety for these populations, and by cultural safety implying a clinic where they come in and it's culturally safe for them to get treatment that aligns with their cultural values, that at least the medical practitioners understand from what perspective these individuals make their decisions. That's a huge struggle. Even in my clinic where, if I am lucky and I saw a white patient who speaks English, that would be a treat. I'm always practicing with interpreters. The thing is, we still haven't figured out how do we practice with interpreters and still provide reproductive care that is suitable for individual cultures. Last 2021 in the fall, I had a lot of Afghan refugees come in, and I think I have a huge number on my panel, huge. And, previously we just had interpreters and that's what, right? Well, now I have a woman in my exam room who, won't talk to me if it's a male interpreter, but I don't know why she's not talking to me, because I just can't create a culturally safe environment for her to express herself. Or in an exam room where I am providing care for a woman who came into with her husband, and the husband is speaking to me on her behalf. And I think we fail these women in this way if we do not understand their cultures and how they perceive medicine and what's our role to partner with them to give them the outcomes they need. And I think about access. In all honesty, even before Dobbs, access was really terrible for people of color, for marginalized populations, because we still saw these inequities anyway. And if you tell me, honestly, if you don't have access, then you have no choice, right? And this is still continuing even today, but still wasn't. A few weeks ago, one of my patients, about 42 years old, was pregnant. She has 6 kids at home. She's Pashto speaking. She really came to me and said, I don't want to have an abortion, And I said, I really don't want to have this child. I gave her all the options and we zeroed down onto the abortion. I practice in law, so we don't have, many clinics in that area, and I cannot provide abortion in a federally qualified, federally funded health center. And so it turned out having to figure out, where is she going to have this abortion? How is she getting to this appointment? Who is going to be the translator in this visit? Putting together the whole picture. It's not my job, but that's the pressure you deal with if you're a person like me practicing in such a setting, that you really want to make sure that people are getting what they're getting. The system is not structured for all these things to be in play for these individuals. So that's the one thing we really want to look, I think this case became very bizarre because it turned out that she, eventually I called Judy and said, I need transport for this individual and all that. And she went, came back to me a week or 2 after for follow-up. We are talking contraception and all these things. And I go to do an exam and she has an IUD and she had no clue, right? So here is the thing, either it was language that someone explained to her, but she did not understand whatever they were talking about, or it was the assumption that we have as practitioners that women of color like me need IUDs. So the moment they walk in and it's contraception, boom, IUD door, because, we leave them no choice. These are the things that keep me awake at night. And what else? There's so many other things, but we really have to do a better job in terms of equity, in terms of education, in terms of cultural safety for our patients and access. We shouldn't even be talking about abortions if we provided access to contraception, if we provided access to adequate knowledge in people's languages, if we supported these women and their partners to make the things happen, right? But we should not be here if we did a good job as a health system to for our patients and with our due diligence. I think the other thing that comes to mind for me is how our playing ground here in the United States is impacting other countries, other healthcare systems. I don't want to get into that, but as someone who does global work, whatever your beds that you're laying in right now in the United States is really messing up other people's, you're worsening their outcomes. So I want us to think about all these things in this picture as we're doing the law debates, stuff like that, to think about. So, we forget about, I see many patients who come in my clinic from the border. They've been there for months, either from some have traveled from other countries through Mexico to come to the United States for so many reasons. Some of them get pregnant while they're there. Some of them are pregnant while they're traveling, and they come to me at 8 months, and they've never even had an OBGYN exam or midwife look at them. And I am the get-go for them to start, oh my gosh, they're 8 months pregnant, where do I start? Can I hear the fetal heart rate? Fine. So all these things that are embedded into the system here that affects my patients' outcomes, other patients' outcomes, we need to think about and do a better job.
Wow. You're saying something about cultural safety, a culture of safety, reminded me that we have cultural attitudes which sometimes make a place not just less safe, but we also perpetuate ideas about what we should be doing medically that are not good for anybody. And my favorite story about this is the whole breastfeeding controversy. Now it's common, you go in, people support breastfeeding for the most part, but dial back a few years ago, a very forward-thinking pediatrician at what was then Boston City Hospital, not Boston Medical Center, Dr. Bobby Phillips, decided that she wanted to see that hospital become baby-friendly in the eyes of the World Health Organization. Remember all the controversy about the infant formula and, killing so many babies in Africa? Well, it's a problem everywhere in the world where you don't have high breastfeeding rates. It can cause maybe not death, but certainly disability and disease. And she wanted to advance the idea that we should get our breastfeeding rates in this hospital high enough that the WHO will give us their imprimatur. Well, she talked to people who cleaned the floors, people who brought the food into the rooms. She talked to anybody in the hospital who worked there, people who did the laundry. She had the most trouble with the nurses who used to run the other way when she came down the corridor. Many of them thought that breastfeeding was cow-like, disgusting. This is from nurses. Didn't have a clue about the huge importance, both for bonding and medical reasons. Anyway, this Dr. Phillips did her job. She was, relentless, and she became a spokesperson, went around to other hospitals in the country. And lo and behold, what happens when you have higher breastfeeding rates? Your NICU population goes down, right? Because you have healthier babies. So the CEO of that hospital, a woman, got a call from someone who ran the NICU, and he was describing a problem, which is that their NICU population was down so that they weren't getting as much reimbursement. And this was a very good example of what we call perverse payment incentives. And of course, her response was, excuse me, that's a good problem to have. You go back to the drawing board and figure out some other way to solve the money problem. It's not to fill up the NICU, because we like the idea the NICU isn't so populated. That is happening throughout the field of obstetrics. And it's one of the reasons midwives have had such an uphill battle. It's one of the reasons Nishira mentioned that the whole culture and climate is so difficult. When I was in Texas many years ago, and by the way, Texas has 40 of those 400 birth centers in the country. Is the irony? More than that, but it's 40 something. It's amazing. You can't get an abortion, but you can get a midwife attended birth and a freestanding birth center. Well, there's the reason those midwives got those birth centers going. I don't have time to tell the story, but it has to do with looking for weak points in the system, making yourself indispensable, providing the services that doctors need, and then getting what you want. And those nurse midwives have become, and now other CPM, certified professional midwives, are a real source of care for childbearing women, particularly in a state which is not known for its institutional enlightenment around racism and things like that. So it's not that it isn't a problem everywhere, but that to me was an example of people looking at fault points in the system and figuring out how, even though money will not flow to the hospital because I have a birth center, we can still make progress. On the other hand, sometimes it's just ideas, it's not money. And I think the reason the Cambridge Birth Center was shut down right at the moment we needed it during the pandemic had nothing to do with money. It's hospital owned, it brings money into the hospital. It has to do with ideologies held by leading obstetricians. Even true in Boston, it's true everywhere. And they won't be public about it. You have to call them out. Even the ones who are supportive of what you're doing this year, I know some who haven't been publicly supportive. Where are they? Privately supportive, that doesn't cut the mustard for me. You have to be public support. You have to be writing to the papers and saying, why is this freestanding birth center shut down? And yes, there are a few people who've been willing to do it, but they're mostly my age, I might point out. It's like Dr. Prime was in the New York Times saying, you know, I'm willing to go to jail because of, I'm in my 70s now, right? But it shouldn't have to fall just on people in their 70s to take risks, even legal risks. But I think that it's really important to think about who in the community can aid a project like the Neighborhood Birth Center. We got the Cambridge City Council up in arms over the shutting down of the Cambridge Birth Center. They had a policy order in September, it was basically unanimous. And their city councilor has to go to the president of the hospital and really pursue this. We're hoping the birth center will reopen. But the real reasons we probably will never know. And they're not the ones that I've heard, you know, through gossip and whatever. Don't make me proud of physicians in leadership when they could have played a much more important role, particularly a birth center that has served community of color in Cambridge, immigrant women. I know a lot of the women who went to this birth center, and how could they even think about shutting it down during a pandemic using the excuse staffing problems, which actually is not the real reason. But so enough venting for me.
Thank you. You teed that up nicely, Judy. I wanted to start with a story of we did a needs assessment in 2016, challenged by one of our advisors that said, you know, if you build it, will they come? So sorry, so we'll. I'm trained at BU School of Public Health. So we did a 3-pronged needs assessment. And one of the responses has stuck out since then, so clearly in my mind. There was a Black woman who responded, birth centers are for crunchy white women. But she's not wrong. She's not wrong. And so I want to unpack that a little bit, and it landed with me because my first introduction to community midwives was through my mom, who is a crunchy white woman. Oh shoot, she's right. And then I gave birth at home, and I'm a crunchy Black woman. So I was like, you know, what does this mean? But I think, you know, as we think about the United States, like as a whole, like our birth outcomes are atrocious compared to other economically advantaged countries, right? And while I am deeply steeped in the racial inequity in maternal and child health outcomes, what that conversation can often lead to is that we want to try to raise the outcomes across a number of measures for Black folks and other folks of color in this country to those rates of white folks. And that's just not good enough. Like, I think that we have to understand that the systems are not working well for anybody. And yes, better for some, right? And a friend of mine did this analysis that looked at the US as if the white population were its own country and continued to compare it to other economically advantaged countries in the OECD. And if we, as an entire country, if we rank 32nd out of 37 or so for infant mortality, and then you look at the white population of the US as if it were its own country, we bump up just one notch on a scale of 37 or so countries. And so I think as we understand the fight for reproductive justice and full spectrum reproductive health care, other countries have also prioritized midwifery and community birth options in ways that this country has not only not prioritized, but actively divested in midwifery. And so while the evidence is robust that says that birth centers meet a triple aim, better outcomes, better experiences, and a cost savings to the system to the tune of $1.9 billion a year if we move just 10% of births from hospital to birth center, just 10%. I'm gonna spit a lot of numbers right now. 85% of births that happen in the hospital are low risk and could happen safely outside. So if we move just 10%, there would be incredible cost savings, but yet I'm having backyard parties in Judy's yard and my yard to pass a hat to open a birth center. And I want to just get clear about the 400 birth centers in the country and how they're financed, because this is really where the problem is, and I'm going to get to the optimism. If you're not already pissed off, I want to just bring you like along. Is that of the 400 birth centers in the country, the number one way that birth centers in these United States is financed is by a midwife's personal savings. So we are turning to midwives to self-finance a really significant piece of our healthcare infrastructure. And when a midwife self-finances a birth center, I would argue it's not working really well for her either. Even if we have a wealthy white midwife, of which there aren't that many. But I think that that's like a problematic, solution to this. And then you add to that how midwifery education and licensure and just access to midwifery has been racially redlined, right? And then you add to that the racial redlining and distribution of capital. Then how then are midwives of color, of which there are 5% of the workforce, and who have less access to capital, supposed to self-fund birth centers to meet the need of our communities? And so, I think about, and then just also just a piece of history that the move from, so as this woman said, birth centers are for country white women, it's because we have been severed from the history that Black midwives birthed this entire country, right? And that there was an economic and power move by the healthcare system and by obstetrics to move birth into the hospital. And so I guess I just want to circle back and say, I think that, this is our focus on this birth center here in Roxbury is really rooted in this idea of bound liberation, right? That if you want to get free, follow Black women, right? That we are creating community-based solutions to structural inequity. And while self-financing in other ways, I don't have the capital to open this birth center, but we are having house parties and we invite your capital. But really, we are also looking to policy and philanthropy to make significant changes, right? That enough is enough, and that the changes that we make to ensure that there is equitable pay for midwives, that there's licensure for professional midwives, that we're not looking to midwives to take a pay cut when they leave the Brigham to come to work at my birth center, and to take a pay cut and work 3 times as many hours. 90 hours a week is what the average birth center midwife works, right? So I think this whole thing is like, let's actually get to the root of the problem and work on policy, and in the meantime, really call on philanthropy and the inequitable distribution of wealth to repair where we have divested community midwifery. And so I feel really optimistic about a movement, a national movement of birth centers led by folks of color that are really demanding a shift in full spectrum capital in the way that we, divest from problematic investments, invest in community-led solutions. And again, with this idea that I'm ending here, John Powell from UC Berkeley talks about targeted universalism, right? This idea that you have a targeted intervention, and then and only then does a rising tide lift all boats. So I think when we have a targeted solution that looks at who bears the most burden based on the structural inequity, how do we design, in this case, a birth center, a solution to meet the needs of disabled Black immigrant trans man from Boston who's unemployed, design a birth center for them, with them, then and only then are we building a really dope birth center for wealthy white crunchy women. So she's not wrong, but we're gonna work on really healing our understanding of history and bringing folks along in that reclamation.
thank you, that was amazing. Okay, let's open up for a Q&A. And I have a couple of questions online. People probably need to gather their thoughts. Yes, Robert.
I have some anecdotal evidence that some crunchy Asian women also.
Hey.
My question actually has to do with what you guys are seeing in terms of long-term strategy. I wanted to pick up invitation Professor Sepper and Professor Mannion invite us to think across issues, but also perhaps structurally. And it seems to me there's sort of two long-term possibilities. I mean, maybe at least two. One is to sort of try to replicate what traditional civil rights people did, which is to focus quite a lot on the courts. And that is to say, focus on electing pro-choice legislators, pro-choice presidents, and then getting pro-choice justices nominated, and then throwing Dobbs out the window, right, and putting Roe back in. Another possibility is to take advantage of the moment and do something much more democratic, but this will require the structural reform. And I'm wondering then if there's any evidence of the second possibility. Is anybody seeing any linking up, given how popular or unpopular Dobbs is, of people interested in reproductive health with people who are interested in the structural reform of the federal courts? So the one judge who is striking stuff down left and right, the Supreme Court of the United States that has an outsized role in policy making in this country. Just wondering if there's anything that people are seeing about linking up with this one.
So by structural reform, you mean structural reform of the court?
Reform of the
court, so things like that report that came out from the butt, which I frankly found not much there. I mean, you know, they didn't really do much with it except grow. I mean, the thing is, I don't think they're separate, right? You can't get structural reform without the democratic grassroots, you know, political change. So I think people are definitely connecting the Dobbs decision with the right to vote and with the court and how much power the court has. There's certainly been more people talking about, well, the court has too much power. You know, we've been living under the shadow of the Warren Court, and so we think of the court as this great protector of individual rights. But in fact, if you look at the whole 2-century history of the court has far more often been an institution that retracts rights, you know, from the civil rights cases and the post-Reconstruction era on forward. I mean, those two things are so tied, because how do we get that structural reform of the court without a mass political movement? So I sort of felt like Biden with that report, I don't know, I felt like it was just a sham.
There are some incremental things, though, that I see happening, because I think there is this outrage over the ethical insensitivities that some of the members, maybe even all of them to some degree, have on the court. And, you know, if we could get, I think I could see you getting a coalition to enact a statute that says, you know, you have to adhere to the Code of Judicial Conduct like every other judge in the country. So, you know, so that maybe would stop them from, you know, going to the Federalist Society and alas, also the American Constitution Society, but stop them from doing stuff like that, which definitely undermines the public perception that they are, you know, looking at things, you know, in any kind of reasonable way that's not influenced by, you know, these, you know, political organizations. And so, I think that that's one thing. And I think also, you know, the Congress, I think, could, you know, pass some statutes to say they can't be so totally in control of their own docket. Because I think that's where we're getting, you know, this whole shadow docket business, all this stuff, it's all just, you know, playing around with the rules. And so I think Congress can make some rules for them around this stuff. And I think that maybe both sides might appreciate it ultimately, because the rules will be clear.
Anyone else want to speak to that? We have to stop actually, because our next meeting will start in 5 minutes and the class has to come here. But I just, before we all get up, I just wanted to ask if anyone wanted to say any concluding comment or thought. No, well, let me just thank you guys for being
And welcome to our fourth panel of the day, Law and the Regulation of Pregnancy, Reproduction, and Parenthood, Post-Dobbs. My name is Shannon Gonick, and I will be moderating. I am a second-year law student here at Boston University, and I'm the president of our BU chapter of If, When, How Lawyering for Reproductive Justice. This panel will address some of the proliferating legal issues in the post-Roe world and their bearing on securing reproductive justice, including access to abortion services such as telemedicine and medication abortion, disability discrimination, surveillance of menstruation and pregnancy, and criminalization of pregnancy and conduct during pregnancy. I will begin by briefly introducing each of our panelists before the presentations, and we will reserve time for Q&A at the end. So first, we have joining us remotely, Dabney Evans. She is an assistant professor of global health in the Rollins School of Public Health at Emory University. Her research is focused on gender, health, and human rights. Then we have Rachel Reboucher and Greer Donley, the latter of whom will also be joining remotely. Rachel Reboucher is the Dean and James E. Professor of Law at the Temple University Beasley School of Law. Greer Donley is the John E. Murray Faculty Scholar and Associate Professor of Law at the University of Pittsburgh Law School. Next, we have Leslie Francis, who is the Alfred C. Emery Professor of Law at the University of Utah. Her research interests lie at the intersection of normative ethics, bioethics, and health law. Then we have Professor Michael Ulrich and Leah Fowler. Leah Fowler is a research assistant professor at the University of Houston Law Center. Her research explores the intersection of law and consumer health technologies. Michael Ulrich is an assistant professor of health law, ethics, and human rights at BU's School of Public Health and School of Law. His scholarship focuses on the intersection of public health, constitutional law, bioethics, and social justice, with an emphasis on the role of law in the health outcomes of marginalized and underserved populations. We will begin with Dabney here over Zoom. Thank you.
Thank you so much. And I really want to thank BU, the entire team at BU, for this incredible event. It has been an amazing day so far, and I'm excited to be a part. And I really want to congratulate, especially Aziza, Nicole, and Linda on their leadership. So thanks so much. Anyone that's ever put together a conference knows it's an incredible amount of work. So really appreciate you all for that. So I come from a public health perspective, and I'm going to try and bring a little bit of public health flair here today, as well as introducing a little bit of empirical evidence from a study that I've done that's called A Daily Reminder of an Ugly Incident, Debate on Rape and Incest Exceptions in Early Abortion Ban Legislation in 6 Southern States. Whoops, can everybody still see my presentation, or did it just go away? Let's do it this way. Okay, hopefully you all can see. This is a second paper that follows up on a narrative analysis that myself and a colleague did looking at early abortion ban legislation in the state of Georgia from 2019. And we expanded within this particular study to look at 6 southern states. And so, first of all, I'm based in Atlanta, which is not only a battleground for control of the US Senate, but is also a battleground for reproductive justice. And when I talk about reproductive justice, what I'm referring to is the reproductive justice movement, which really has a lot of strong foundations here in Atlanta. And I'll be talking a little bit more about that in just a second. But just as background, to the data that I'll be presenting today, and I think this will not be news to anyone in this room, safe and legal abortion has been and is increasingly difficult to access in the US, and is, as we know now, highly dependent on context, but really in truth, it always has been. We know that there have been many pieces of legislation that have put limitations, including trap laws, and other federal legislation even that has included limits such as the Hyde Amendment on access to abortion. Beginning really as far back as 2011, but especially in 2019, many of us will recall that there was this spate of early abortion bans, sometimes called fetal heartbeat bills, but I refer to them as early abortion bans because that's really what they are. And there were 25 of these pieces of legislation introduced in 2019 alone. And in the state of Georgia, and I'll be talking about some other states, that was House Bill 481. And in some of these pieces of legislation, but not in all of them, there were exceptions for rape and incest. And I think most people will probably know that in most abortion legislation, there are three primary types of exceptions. Those include for the life of the mother or pregnant person, for fetal anomaly, and for rape and incest. But in some of these bills in 2019, some of which are now in effect, rape and incest exceptions did not exist, as was the case in Alabama. So this is a new problem that we were facing. And so what my colleagues and I really wanted to do was we wanted to look at legislative debate as a form of public health data and really treat the way in which legislators and the public were talking about these issues as they were considering these pieces of legislation. And of course, the reason we're all here today, we know the Dobbs decision reversed Roe v. Wade. And I also want to highlight, and I was very pleased to hear it uplifted as well in the prior session, that in 2023, just this past weekend, reproductive justice leaders convened here in Atlanta, and they released this statement, which is about visioning new futures for reproductive justice. The declaration is available on the Sister Song webpage, and I want to encourage everyone to have a look at it. It reinforces and underscores the pillars of reproductive justice and what that actually means. And I think that it's really, really important for all of us to bear these principles in mind as we think about reproductive justice as well, not only in the law, but in the lived experiences of people as well. So I just want to make sure that I uplift that work. So diving a little bit into the study that we're doing, I use Georgia as an example because that's where I'm situated, but many of you will be familiar with the New York Times report that came out last year that talked about and compared the many health issues and the health status of women and children relative to what their abortion legislation was. So what you're seeing on the right-hand side of your screen is the New York Times data, looking at children in poverty, uninsured women and children, low birth weight babies, and several other major health metrics, including infant and maternal mortality, and looking at those rates relative to whether states were restrictive on abortion or not. And then on the left-hand side, what you're seeing is how Georgia does as one state in particular. And what you see pretty much across the board is that we do worse than everywhere else. So I think that's really important. I'm going to be focusing in on the South here. And the South is a place where these abortion bans are in existence and where our health indicators are really, really poor for women and pregnant capable people as well as children. So in terms of our methodology, as I mentioned briefly, what we did was we actually looked at publicly available video archives from House, Senate, and committee meetings in 6 southern states, and I'll specify which states in just a second. And what we did is we actually took the debates that took place, and by the way, it wasn't easy to get these video archives, even though there are some states that have law on the books that says that these things are supposed to be publicly available. So just a note, that's an opportunity for some legislation to have these House and Senate committee meetings documented really well, because there was one case where we had to rely on outside organization for those data. And then what we did when we got those publicly available archives is we conducted a narrative analysis. So we treated these as qualitative data. We transcribed them verbatim. We coded them both deductively and inductively. And we focused on a particular time frame, which was the 2018 and 2019 legislative sessions in these 6 states. And we included testimony from what we call proponents and opponents. We did not frame this in terms of Republican or Democratic legislators, or although we do know who was who, but we also had members of the public. And so we wanted to not put people in buckets based on necessarily their political affiliation, because as you will see, there were some surprising instances where folks from either political party sort of spoke on one side of the issue on another in surprising ways. The data were open coded and analyzed using a constant comparative method to identify themes. And the richness of the data and the topics varied across states, but I'm going to be talking about them as a whole today. So the 6 states that we looked at were Georgia, Kentucky, Louisiana, Mississippi, South Carolina, and Tennessee. And several of the states included rape and incest exceptions. These were Georgia and South Carolina. The other states did not include exceptions for rape and incest. And you can see in the second column, the bill number or the Senate bill or House bill number. And some of these have gone on to be a part of law. And you can also see what the exception details were and kind of how it was phrased within the law within each of those. And so as you see, these connections sometimes to medical emergency, as is very common and we're familiar with. So 3 core themes emerged from the data, and I'll talk about each of them in turn. But just briefly, the first one was that belief in women and girls' claims underpinned opposition or support for rape and incest exceptions. The second is that opinions about trauma were related to views on exceptions. And the third was that exception supporters called for empathy and nonpartisanship in consideration of rape and incest experiences. So I do want to warn that we do have some qualitative data here where people are talking about experiences of sexual assault. So just so that everyone knows that and can take care of themselves as they need to. But on this first theme, what we really saw here is this idea of trust women, which has been a rallying cry among women's rights supporters for many years. But really, in fact, what we know very well is that women are not trusted. And frequently, their accounts of rape and incest were frequently questioned. And in addition to not just trusting women or pregnant people to make decisions about their own bodies, but actually that when they say that they have experienced sexual assault, either rape or incest, they are frequently not believed. And of course, we know this is true. We all also have lived through the Me Too movement, and we know about the stigma and issues around disclosure that, where people haven't been believed. When it comes to abortion, this was layered on with the idea that it was actually a responsibility of personnel within systems and institutions, particularly law enforcement and even medical doctors, to fact check victim stories, right? So sort of the burden of proof is on the victim in this case to prove in some sense that they have experienced rape or incest, even if they're not making a legal claim about rape or incest, but instead they're trying to make a medical claim or access to, make a claim on access to medical care. So we have one quote from a Democrat in South Carolina, a legislator. The legislation said that a doctor had to give his belief as to whether this pregnancy occurred because of a rape or incest, because this body, the state legislature, through its own toxic masculinity over the years, has never believed that a woman can be trusted to tell the truth, right? So calling upon medical doctors to actually say whether this person was raped or experienced incest, which of course can be difficult to document. But really, is this what we want to call upon our health professionals to do in cases where people are trying to access a healthcare service? The second thing related to trauma, and I mentioned earlier the Me Too movement, and bearing in mind that these were the 2018-2019 legislative sessions right on the heels of that movement. But the experience of trauma, and what we know is that many incest and rape survivors do not disclose their experience, sometimes for years. But in fact, this idea of having to prove that one was raped or experienced incest, directly conflicts with the time-sensitive nature of abortion access, especially when we're talking about these early abortion bans where we need to make a claim on abortion rights before 6 weeks of pregnancy. Or otherwise, if after that, in the case of reception of rape exceptions, have to jump through these additional hoops. And so views of trauma were really important. This idea that supporters of exceptions, rape and incest exceptions in the law, used a combination of talking about physical and emotional repercussions of pregnancy as a rationale for the exceptions. And protection of the fetus was positioned in opposition. And we know this is a false equivalency that has been used in many abortion pieces of legislation. that the argument that fetuses are innocent or that fetuses have no control, but they should be viewed equally as the person who was the victim or the survivor of rape or incest, and that these fetuses deserve protection. And of course, this ties directly to the personhood argument that's present in all of these fetal early abortion bans as well. So again, here, a Democratic senator from Louisiana: have you given consideration to the protection of a female who may have been violently raped, or about a perpetrator who in that process became pregnant, and the horrific stress and emotional strain and the difficulty of having to endure that? So basically this idea not only of forced pregnancy, but also layering onto that the idea of the trauma of the sexual violence that the person may have experienced, the emotional and physical aspects of that violence. And then the third theme was a call for empathy and nonpartisanship. And I don't say bipartisanship, but rather nonpartisanship when considering rape and incest exceptions. So supporters of rape and incest exceptions used examples of familial and personal relationships to encourage empathy. And I heard in an earlier panel, an example of Republican men coming forward and thinking about their own daughters and their own sisters and perhaps their partners. And this was something that also came up here as well. And as well as the assertion that the consideration of rape and incest exceptions should be a nonpartisan issue, and for many years has been a nonpartisan issue. So this idea of rape and incest exceptions being controversial is new, and something that we still have to, relatively new, and something that we have to grapple with. So what I'm going to ask you to do is picture your child being raped, crying to you, not understanding, having to suffer the consequences for something that was not their own doing. And we did even have cases of legislators who shared their own experiences of sexual violence in this regard as well. So quickly wrapping up, our conclusions, the themes that emerge from these data, the results align with a well-documented history of rape myths and rape scripts in the US. And really this idea of doubling down on the science of distrust, a big piece of these early abortion bans that we discovered in our earlier narrative analysis was this idea of taking or making science sort of, fake science, fake news, fake science, and really misconstruing it. And I think that this science of distrust, right, this idea that we can't believe women when they make these claims really was related to this. Now we need healthcare professionals or police to document and prove this, creating, burdens on the person that's seeking abortion care, which is nothing new. And the fixation on gatekeepers being really a distraction from the need for safe and legal abortion. Our findings align with the primary premises supporting the anti-abortion arguments around fetal personhood. And again, that false equivalency, that the fetal rights are equivalent to the pregnant person's rights. And the one thing I'll point out is that this legislation is often copied and is really based on model legislation and has been replicated over and over again. And so it's really important for us to strategize across party lines, across movements, and really build upon the efforts being led by Black female-led organizations, including Sister Song and others in the reproductive justice movement who are leading the way in terms of advocacy in many ways. So in terms of action items and recommendations, of course, we're now all facing the ugly realities of life under these abortion bans, but also legislating. And I think that these ongoing, sort of current legislative sessions are really going to show us a lot about where anti-abortion advocates are going to go and anti-abortion legislation is going to go from here. And we know that they're going to continue to advocate for further and further restrictions. There have been a lot of divisions, especially right when the Dobbs decision came down. We heard this case from Ohio, and I think of my own child who's almost 10 years old, who, in some cases isn't tall enough to go on a roller coaster, but if they were a survivor of incest, would be expected to not only disclose that incest, but also try and make a legal claim in order to get abortion access. One consideration that has come to mind is that in many states, there are rape laws, and sex among people under age 18 is considered rape. And so what does this mean? All individuals under 18 having sex could be considered rape. There's a double-edged sword, right? In lots of ways around that in terms of consensual sex among people under age 18, but something to consider. And then tying to those data at the beginning, what does being pro-life mean now? And what does it mean for family supportive policies? So just looking forward, I think that everyone is familiar now with the personhood argument, but this isn't stopping. What I've got here is some legislation from South Carolina, which is super problematic language that not only categorizes a child as a pregnant woman, so that we're not even talking about girls or children anymore. We're just sort of making them adults by the nature of pregnancy, and also misgenders pregnant people within the legislation. So really important to watch the language that's coming out in ongoing sessions right now. And of course, I have to keep myself at work here, so we need further research on ongoing legislative debates and lots more work to do in that area. I do want to uplift and probably leave this as my last slide. These are the tenets of reproductive justice. This is the statement of reproductive justice that came out by Sister Song and a coalition of activists. And so really encourage everyone, again, to look at that as a way forward, a positive way forward for what we need to be working towards, so that reproductive justice is a reality for all of us.
Hello, good afternoon. Thank you so much for inviting me to speak, and thank you for, do we need to pull up Greer? Yeah, okay. Anyway, thank you very much. Thank you to Linda. Thank you to Nicole. Thank you to Aziza. Thank you, Shannon. Our topic today is FDA policy after Dobbs. Thankfully, there's